news. So please pray to God for those who are pass away. Let have the best place in the hereafter. For those who are left behind, patience and also resilience be with all of us. And to those who still live here, will be more productive, more happy, and with a good immune system. Stay healthy, be happy. And congratulations once more to this conference. I wish everybody is happy, everybody is open, and everybody is ready to share all experiences. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Closing. Let's close our agenda today by reciting Alhamdulillah.
And on behalf of Committee of Annual International of Law and Sharia, we sincerely ask and apologize for all mistakes have done. Thanks. Wassalamualaikum warahmatullahi wabarakatuh.
Launched at August 14, 1950. The PTAIN was then officially launched at September 26 in the following year. In addition, at August 24, 1960, the name of PTAIN was changed to IAIN. The former PTAIN was further divided into Sunan Kalijaga. It applied the curriculum and replacement of the former PTIAN curriculum, which was originally adopted from Al-Azhar University in Cairo, Egypt. The next period, in 1972 to 1996, the foundation and institutionalization period. Several infrastructure developments were done, including the construction of Dakwah Faculty, library, graduate program, and rectorate buildings. The education system was shifted from semi-credit to pure credit system. In the period of academic and management establishment in 1997 to 2001, some academic improvements were conducted, especially addressing on the problem of overseas. In the transformation period 2001 into 2010, a fundamental change did happen in which IAIN was shifted into State Islamic University or UIN 2004. This transformation implied the introduction and the development of integration interconnection paradigm in which what's so-called Islamic sciences and general Western origin sciences should be in a dialect. Blending between those two kinds which were treated to be separated and diametrically different before was expected to give birth on an understanding that Islam is friendly, democratic, and rahmatan lil alamin. 2020 to 2024, the vision of Rector is Sunan Kalijaga State Islamic University for the Nation, SKSIU go globally. The total number of academic staffs are 674, with 34 professors and 257 PhDs, and the total numbers of supporting staffs are 520. Students from Indonesia and 105 students from overseas such as Malaysia, Turkey, Afghanistan, Bangladesh, Egypt, Thailand, India, Russia, and Algeria. There are 3 locations, Sambilegi, Pajangan, and Sapan District as central administration and academic affairs. There are 25 buildings, cover 8 faculties and interdisciplinary graduate program. A graded for institution accreditation. From 61 study programs, 35 of those A accredited by our National Accreditation Board and 6 study programs are certified by AUNQA. There are 72 cooperation internationally. Professor of the Ideology of Pancasila Development Agency, Professor Nizar Ali Cultural Sciences Commissions, Scientific Director of Indonesian Science Fund, the Advisor of Indonesian Association of Religious Sociology, and the member of Parampara Praja, Provincial Governor Special Region of Yogyakarta, Professor Nurhaidi MA MPhil PhD, the member of Indonesian Academy of Cultural Sciences, the Association of Leading Indonesian Scientists, Professor Alimatul Kiptiah PhD, the Commissioner of Women's Human Rights, Dr. Siti Rohaini MA, Presidential Republic of Indonesia in the field of MA, the Ambassador of Indonesia in Saudi Arabia, Professor Dr. Mahasin MA, the member of Executive Committee Asian Conference of Religions for Peace in Tokyo, the former Director General of Islamic Education, Professor Munir Mulhan PhD, Director of Suftisisasi Sharia, Dr. Tulus Mustafa PhD, the head of Arabic Teacher Association of Indonesia.
Islamic State University is for our nation, and Islamic University, or at least we are prepared for globalization. We are really indeed must be ready, must be well prepared to face all kind of challenges in order to contribute something to this nation. And also we are ready to engage with many programs of internationalization, and we are not going to avoid, but we welcome globalization. And thank you very much for your attention. Assalamualaikum warahmatullahi wabarakatuh.
since September 26, 1951. At 1951 to 1960, it was legalized with the Presidential Decree Number 34 launched at August 14, 1950. The PTAIN was then officially launched at September 26 in the following year. In addition, at August 24, 1960, the name of PTAIN was changed to IAIN. The former PTAIN was further divided into two IAIN. One was in Yogyakarta and another one was in Jakarta. The one located in Yogyakarta was named after one of the Javanese great saints, Sunan Kalijaga. It applied the curriculum and advancement of the former PTAIN curriculum, which was originally adopted from Al-Azhar University in Cairo, Egypt. In the next period, in 1972 to 1996, the foundation and institutionalization period. Several infrastructure developments were done, including the construction of Dakwah Faculty, library, graduate program, and rectorate buildings. The education system was shifted from semi-credit to pure credit system. In the period of academic and management establishment in 1997 to 2001, some academic improvements were conducted, especially addressing on the problem of lecturers' qualities. The lecturers were given the opportunities to pursue higher academic degrees, both master's and PhD levels in various academic disciplines, both in Indonesia and overseas. In the transformation period 2001 into 2010, in which IAIN was shifted into State Islamic University or UIN at June 21st, 2004. This transformation implied the introduction and the development of integration interconnection paradigm in which what's so-called Islamic sciences and general Western origin sciences should be in a dialect. Blending between those two kinds which were treated to be separated and diametrically different before was expected to give birth on an understanding that Islam is friendly, democratic, and rahmatan lil alamin. Our core values are 6 pillars: leading an excellent institution in integrating and developing Islamic values and science for the advancement of civilization. For the 2020 to 2024, the vision of Rector is Sunan Kalijaga State Islamic University for the nation, SKSIU for professors and 257 PhDs, and the total numbers of supporting staffs are 520. 21,649 students from Indonesia and 105 students from overseas such as Malaysia, Turkey, Afghanistan, Bangladesh, Egypt, Thailand, India, Russia, and Algeria. The total numbers of journals A graded for institution accreditation. From 61 study programs, 35 of those A accredited by our National Accreditation Board and 6 study programs are certified by AUNQA.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Puji syukur marilah kita ucapkan kepada kehadirat kita Allah Subhanahu wa Ta'ala yang telah memberikan kita rahmat dan karunia-Nya pada pagi hari ini. Salawat dan salam tidak lupa pula kita hadiahkan buat Nabi besar kita Muhammad sallallahu alaihi wasallam. Yang sama-sama kita hormati Rektor UIN Sunan Kalijaga Yogyakarta, yang sama-sama kami hormati Dekan Fakultas Syariah dan Hukum UIN Sunan Kalijaga, beserta jajaran dan partisipan yang sudah hadir pada pagi hari ini. Dan yang kita banggakan, para narasumber yang sudah hadir bersama kita pada pagi hari ini. Yang pertama, Profesor Dr. Amina Wadud. Yang kedua, Profesor Dr. Handus Haji Ratno Lukito, MA DCL. Yang ketiga, Dr. Said Masud Nuri, NU Law School. Selanjutnya diberikan kata Ibunda Siti Munah Hayati untuk membuka acara diskusi kita dan dialog. Ibunda Siti Munah Hayati, disilahkan.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin. Assalatu wassalamu ala asyrafil anbiya'i wal mursalin sayyidina maulana Muhammad wa ala alihi wa sahbihi ajma'in. Amma ba'du. Good morning everyone. Welcome to the 5th Annual International Conference on Law and Sharia presented by Sharia and Law Faculty of State Islamic University Sunan Kalijaga Yogyakarta. It's nice to be here with all of you. I'm Siti Munah Hayati and I will be the moderator of this session. Today's conference is about practice of Islamic family law and Islamic legal system. And for that we have 3 speakers here. The first one is Professor Dr. Amina Wadud. She is a visiting professor from United States. Hello, Professor Amina. I hope you can hear me well there. And the second one is Professor Dr. Handus Haji Ratno Lukito, MA DCL. He is a professor of comparative law at Sharia and Law Faculty, State Islamic University Sunan Kalijaga Yogyakarta. Hello, Professor Ratno.
Hello, good morning.
Good morning. And the third one is Dr. Said Masud Nuri from New York University School of Law. Ladies and gentlemen, in this session we have time until 10:30 a.m. But because Professor Amina Wadud has some schedules this morning, so she will give her presentations now for 20 minutes, and then we will have some discussions with her for 10 minutes. So in that session, please feel free to raise your hand or write in the chat room if you have something to ask or you have any comments for her. And please feel free to speak in Bahasa. Okay, for the first presenter, we have Professor Dr. Amina Wadud. She will speak about lessons in reform from Muslim women's movements for justice in Muslim personal status law. Professor Amina Wadud, are you here?
Yes, I am here.
Hello, Professor. Nice to meet you.
And there's an echo.
Sorry?
Think about that. There is an echo. I need to share my screen. Okay. Can you see my screen?
Yes, yes, we can.
Unfortunately, I can't see it. I'm going to go ahead and present. but I just need you to know that there are residual noises and other people have their mic open or something, and I'm hearing lots of noises, and I'm hearing myself.
Okay, wait, we will unmute some of them.
I'm just going to get started because otherwise I will not finish on time. So I'll try to ignore the sounds. Inshallah.
Please wait for a moment,
All right,
Professor.
so
We will unmute them.
first I need to give a context for a discussion of the overall idea about human rights, because actually as a human civilization, we have a particular historical development in this discussion, and it is directly related to the establishment of the nation state, and in the previous century to the occurrence of what were called world wars, because in the context of those world wars, we learned that we can do horrific things to others whom we consider to be human, and there was a international level of discussion. Coincidentally, this discussion coincided with the end of the empire, not necessarily present the optimal possibilities for confirming the value of all human life, but that's another discussion. So with the discussions about what does it mean to be a human being in the context of the establishment of a union formed between those nations, now known as the United Nations, a particular framework for the discourses was established, and that framework was defined as universal. I just want to say that in the context of Islam and Muslims, we became a part of that globally understand what are human rights. But these discussions were not dominated by anything particularly Islam or is stated in by Muslims. So when we look back over this discourse, I feel sometimes we have to unpack what happened along the lines of the consideration of such a thing as human rights before I will address some specifics with regard to Islam, gender, and particularly Muslim personal status law and the nation state. So whenever we think about human rights, the first thing we have to think about is, well, what does it mean to be human? And even though that seems to be often taken for granted, especially by other humans, even when those humans have participated in violating the humanity of others, we don't step back and look at it epistemologically. So in the context of Islam and its own internal dialectic, there was never an assertion of such a thing as universal. We just came to derive universal from the sacred sources, the Quran, the established Sunnah of the Prophet, upon him be peace, and his speech as recorded and verified through the sciences of Hadith. So like the United Nations, our notion of what it means to be human is developed from an eclectic source base. And in particular for me, when I look at the Quranic discourses, I think about principles like karama, because the Quran says, "Laqad karamna bani Adam." We have given karama, or human dignity, to all of the descendants of the original person whose name was came to be. Greco-Roman and Hellenistic tendency to divide human beings into particular classes or categories. And one of the most interesting of these categories is the category known as slave. The very idea that a person could become under the ownership of another person was a practice already in play at the time of the Prophet and his receipt of the revelation from Allah in the form of the Quran. But that idea, as we understand it today, especially for myself in particular, because I descend from people from Africa who were enslaved in the Americas, the idea of slave is abhorrent to us today. So again, this is just to give some kind of implication on how certain ideas under the understanding of human rights are the product of human development and human civilization, as well as human spiritual and political reflections. So the establishment of the Greek system was divided into a priority on the basis of gender. So male was considered above female. On the basis of citizenship, Islam and Islamic philosophy and law embraced this way of life, all other religions. And this is a perspective that still undergirds much of Islamic law today. When the global discourses over human rights began, as I said, in the previous century, particularly after what was known as the World Wars, the establishment of a universal declaration of human rights, I want to say was contested, but let's just say it was engaged by Muslim leadership. And this Muslim leadership established their own universal Islamic declaration of human rights, which cannot be seen as much more than reactionary. And the basis of it was to both affirm the notion of human rights through the language and discourse of Islamic jurisprudence. So when I started my comments, I said I would sort of unpack this with regard specifically to women and in the context of gender, because this is where I've given the most time in my own work. And I refer to a consideration with the development of feminism also in the global north, also in the previous century, where one such feminist, Simone de Beauvoir, said that feminism is the radical idea that women are human beings. And this idea of attaching the word radical before it is always of interest to me, because actually, most of the time, you cannot find someone who will say that women are not fully human beings. It's just that when you look at legal systems, cultural reflections, ritual practices, aesthetics, there is such a divide, and that divide is not because diversity is beauty, at least in my estimation. That divide is because something attributed to female becomes automatically less than something attributed to male. Look at our discourses in the monotheistic traditions with regard to God or Allah. Most of us consider God to be male, but we also try to pretend that that means neutral. And yet there is no other designation for male that is specific. So in the context of looking at the ideas of gender equality in Islam, as a theologian, I gave my attention to how notions of the human being are developed across Islamic sacred texts, and then how those texts are put into application, let me just say tongue-in-cheek, by men, in other words, by humans, mostly men, and when they are put into systems, especially legal systems like Muslim personal status law or Muslim family law, they have been and they continue to be put in such a case where women's radical humanness is subsumed either under men or under institutions like family. In other words, women do not have the opportunity to establish themselves independently along the lines of what the Quran has assigned them to be, which is Khalifa on the earth. Inni ja'ilun fil ardi Khalifa. Indeed, I will create on the earth a Khalifa, an agent who works directly in relationship to Allah to establish justice and dignity on the earth. Women's participation in this khilafah or agency, which if you look at legal structures across time in the context of Muslims, is always subsumed under something else. She has no direct relationship to Allah. This is something that I found most interesting. I'm going to skip ahead, but then I'm going to come back to this page because I want to give you a depiction of this in the systems in which such a thing was created. Let me see if the graphics are going to work for this. No, they're not going to work. So I'm going to have to start with this one. In most of the, let's see, how do we go back? In most of the discourses over relationships between people in the context of Islam and a belief system that is centered on the reality of a sacred creator known as Allah, the structure is such that the male is above the female. I'm going to have to depict that here because my graphics are from a PowerPoint and they don't fit into Google Slides. So it goes Allah, male, female. Now, when I used to look at this, I used to say there's something wrong with this model. And the main thing that was wrong with that model is that the female here, not just because she was below the male, but that because she had no direct relationship to Allah. This structure does not allow for her to have a direct, unmitigated relationship with the source, the creator, Allah. And that's why I created the Tawhidic paradigm, the purpose of which is to allow for always be in a direct relation for men to be considered superior to women. I ended up with needing to plot it out this way. And when you emphasize this continual relationship with Allah, and again, this is one human and another human in relationship to Allah. This is not male or female, even though this is how I first grafted it. This is not, what I want to say, Muslim and non-Muslim. This is human to human in relationship to Allah. When you graft it this way, as Allah remains the highest focal point, what ends up happening is that every line of direct horizontal reciprocity with every other so the opportunity to work on the establishment of this theological framework in the context of Muslim personal status law was presented to me, a person who comes from a country that does not have Muslim personal status law, and in the United States it shuts, and we would never agree on whose system we put into place. So in this way, diversity is not just beauty, it's also a blessing. So I can't work on it in the direct context of the United States, but I have worked for at least 30 years in organizations primarily organized by Muslim women whose dignity, karama, and whose he came before Islam, and inshallah it will be dying soon. But the patriarchal system is the system based on hegemonic binaries, where whenever two things come together, one has to be considered better than the other. And that's a kind of satanic logic, which also has references in the Quran. But working with groups like Sisters in Islam right next door in Malaysia, and working with Musawa, which is a global network for the reform of Muslim personal status law, I was able to apply the Tawhidic paradigm to the on-the-ground advocacy work that is done by Muslim women. So for the last 2-3 minutes that are left to me, let me just say a little bit about how it is that they address this. because how we maintain and establish our practices. And in the context of Muslim majority nation states, take for example Indonesia, which is a secular democracy with a principle of Pancasila. So in other words, the state itself operates as a non-religious institution, and at the same time it ignites. When we adjudicate our welfare through the state has either the obligation or the possibility to support those rights or to violate them. In the context of Muslim personal status law, many Muslim majority nation states were granted their independence from their colonizing power on the grounds that they maintain a positive legal system, but that the permission to maintain their own cultural values in the context of matters of family, children, divorce, inheritance, and the like, created a subcategory of the law in which people could use the language of Islam to detract from the basic rights of equality. When a woman marries a non-Jordanian man, she cannot pass her citizenship to the man and to their children, her children, because she is not given the same level of legal agency in the context of a discourse that is surrounding supposedly Islam. So what Musawa has done is to establish a three-pronged approach to challenging this unequal status. They use the Constitution. So if the Constitution allows for you equality of citizenship, then it should be extended to every citizen equally. They also use the international instruments of the United Nations, like CEDAW, the Convention for the Elimination of all, defer to suspend on the grounds of Islam. And that's where the third leg of this project, which is to use Islam's own theological base, at least 60 nation states that they have worked with, Musawa, what they do is to propose a challenge to any laws and any policies that would deny a woman her full human dignity and try to attribute that denial to Islam. Thank you very much.
Thank you very much for Professor Aminauddin for your presentation. And we will have 10 minutes for discussion here. Anyone who has something to tell or to ask for Professor Aminauddin, please raise your hand.
I don't know if anybody's talking, but I am done with my thank you very much. So,
pardon me, Professor? Do you have any time for some discussion for 10 minutes?
You're mute. You're mute. Everybody's mute.
Can you hear me? Can you hear me? No? Okay, can you hear me? Sorry? Oh, I'm so sorry for the trouble. Okay, thank you so much, Professor Aminauddin, for your presentation. And now we will have 10 minutes for dialogue here. Please, anyone who have something to ask or want to give any comments, please raise your hand.
I just want to say while we're getting questions and comments that normally I take like 3 hours to try to present the same material. So I hope that it's clear, and if not, I'm available to make any further discourses providing a little bit more detail if anyone is interested, so please.
Any question? Any question for Professor Aminauddin?
Okay, thank you very much, Professor Amina Wadud, for very good explanation on how Islam that is actually very much creating the idea of human rights and like that. Um, I have some trouble question about what if then Western idea about uh, origination or originate or the creation of human being, which is no different between male and female. Yeah, actually, uh, how then the Western tradition create this idea to sort of make the same between the two genders, something like that, because as we know that in the West, the idea of female and male as the same gender uh, seems it doesn't come very long time ago. It just kind of come lately. But then now the situation in Islam then it seems that Islam becoming the very focal point of putting as a mistake for this kind of gender relationship. Yeah, thank you.
Okay, first of all, I'm not an expert on something known as Western traditions. Actually, I'm an Islamic scholar and I've spent 50 years in that pursuit. However, I am from the West, so I've had some anecdotal experience. And also, as I said, because of working with groups like Musawa, I have worked with the United Nations. So I think that you have a misunderstanding with regard to the West promoting the idea that the two genders are the same. This is not a Western idea. This is a misunderstanding. And instead, if you look, for example, at the UN, and particularly in terms of not only ratification but implementation of CEDAW, the Convention for the Elimination of All Forms of Discrimination Against Women, you see they use what's called a substantive model of equality. Nobody, nowhere is saying they are the same. Also in Islam, particularly from the Quran, they are not the same. Laysa azakar kal untha. But instead, they have the right to the same equality as offered by the legal systems of the nation state. However, they cannot access those until their substantive differences are taken into consideration. And that's why we use the substantive model of equality, not the model of sameness. I have no desire to be, because Allah made me to be uniquely me, and I can only fulfill my purpose before Allah uniquely through me. So it's not a question of being the same. This is a misconception that's always asserted in such a way as to create a dialectic which is nonsensical, because no two persons, not even identical twins, can ever be exactly the same. The problem is that we are not given the same access or opportunity, let alone affirmation of the right to the same resources that are made available in our systems. So we are not making persons the same, we are making opportunities, resources, and the like as the same, and that will require very different strategies. So the way we depict this in the work of Musawa is 3 kids are trying to watch a baseball game or soccer game, football game on the other side of a gate or fence. They're 3 different heights, these children, and they have 3 blocks of wood. If you give each of them exactly the same amount, the fellow who is tall enough to already see over the fence has such an advantage that is not even needed. And the person, fellow or gal who is just slightly short can now see, but the person who is a little bit more short cannot see, because each one of them has been given the same in order to achieve the same access to the resource. So instead, the short person needs 2 boxes, the The tall person doesn't need a box at all, and the person of medium height needs a single box. That is the substantive model of equality. It is not about sameness. It is about providing the means to allow for access to whatever is the resource, the goal, the objective, the physical or whatever. So no, we're not talking substantive equality. And in my case, I'm talking about reciprocal equality on the grounds of Tawheed.
Okay, thank you so much for your answer. It's already 9 past 30 a.m. So I think we have to close the session for you, Professor, so you can do your schedules. But before that, we have a certificate for you, Professor.
Sorry for the trouble. Okay, we have a certificate for you, Professor Amina. The certificate we have on you, Professor.
Thank you very much. Wassalamualaikum.
Thank you so much, Professor Amina. But before you leave the session, our Vice Dean, Mrs. Sri Wahyuni, will have some words for you.
I'm not leaving. I'm just going to turn my video off.
Oh,
I'll be
okay,
here
okay.
for this whole session, inshallah.
Okay, thank you. Mrs. Sri Wahyuni, Dr. Sri Wahyuni, are you here?
Okay, from Amina Wadur. And here, Dr. Sri Wahyuni, Vice Dean of Sharia and Law Faculty. On behalf of the Faculty of Sharia and Law, we say thank you very much for you and good appreciation for you to join this conference. Thank you very much. Thank you and thank you. Thank you, Mbak Muna.
Thank you, Dr. Sri Wahyuni. Okay, now we listen to the second presenter. We have Professor Dr. Andes Haji Ratno Lukito, MADCL. Hello, Professor Ratno.
Hello, hello.
Yes, he will speak about Islamic and Western human rights, reconciling the same understanding. Time is yours, Professor.
Okay. Assalamualaikum warahmatullahi wabarakatuh. There is echo. There is echo. Anyway, thanks very much for the committee of the conference. Very wonderful. My gratitude to Professor Amina Wadud for the first term of the presentation, which is very good. Hello for everybody joining this conference. civil and political rights, 1966, and religion in international law would say that religion must adjust to what international human rights laws adapt whenever there are discrepancies. Yeah. So the teaching of religion should be adjusted to the international human right. This is also the approach of some Muslim international law scholars to the debate on Islam and human rights, albeit to different extent and in different ways. Some scholars say that no exception can be argued by Islam, and others say that Islam and international human rights must both accept some changes to adjust to each other. But then this is challenged by relativists. In relativism, the idea of cultural relativism in human rights is that there shall be no claim of inherent truths of human nature. Rather, the truths are dependent on the norms and expectation of particular cultures. Therefore, human rights depends on its cultural context. The term culture here is brought to include indigenous traditions, customary practice, and political as well as religious ideologies. Hence, a relativist will argue that notions of human rights necessarily differ throughout the world because the cultures in which they take root differ. It follows that the Western concept of human rights should not be imposed on nations that have different standards of human rights. The issue of cultural relativism only emerged toward the end of the Cold War as a response to the universal claims of international human rights ideas. The idea of cultural relativism postulates that culture is the only source of legitimate moral rights or codes. All cultures have the same right to live and dignity which must be respected. Thus, human rights must be placed in the country. With this argument, cultural relativism states that there is no such thing as universal rights, which is a rejection of the view of universal rights, especially if these rights are dominated by a particular culture. Relativism holds that the protection of universal human rights is a form of cultural intervention or cultural imperialism from Western nations. This universalism destroys cultural diversity and forms of cultural hegemonization toward one modern world. According to Howard, cultural relativism is a conception of cultural absolutism, which states that the culture of a society is the highest ethical value. Human rights cannot be supported if their implementation results in changes in culture itself. Then the implementation of human rights must be adapted to the culture of each country. Now I should say to you also about the argument for the relativism. Yeah, they say that 24 Muslim majority states have reservation primarily on the ground that certain provision of the CEDAW, I give here the example of the CEDAW, especially Article 16 thereof, are contrary to Islamic teachings. In addition, Niger has declared inter alia that Article 2D and F, 5 and 16C, E and G cannot be applied immediately as they are customs, religions, and levels of literacy. Singapore has a reservation on Article 2A to until 5, 16.1A, C and H, and 16.2 on the ground of religious personal laws. Micronesia, a non-Muslim state, has reserved the right not to apply Article 2F, 5 and 16 to marital custom. This is not to mention that some states, such as Sudan and United States of America, are not even parties to the CEDAW. The truth is that even if Islamic law is really that diverse in practice, then this adds more evidence to the relativistic nature of international human rights. There is less merit than to claim the so-called universal international human rights as a standard for everyone. Yeah. Scholars of international law have used the post-colonial theory to look back in history and have found that there was a hegemony of international law imposed by the West through colonialism under the assumption that other non-European cultures were backward and uncivilized. Based on such an assumption, the Western colonial our agenda now is how to reconcile between the two, how to reconcile between universalism versus relativism. If we use one and nothing, we use um, uh, the, the 0 and 1 approach, then there won't be any reconciliation. But let us think about reconciliation. Numerous Muslim thinkers and scholars of international law have used cultural relativism as a basis either for arguing extreme relativism by rejecting universalism in its entirety, or arguing limited relativism, or generally agreeing to some extent the idea that rights will depend on its cultural context. Even some conventional agrees that the logic of relativism can be acceptable in international human rights as long as it does not breach certain issues he argues to be universal. So, for some universalists, there is also idea to see the relativism as something very good too, right? In the context of international human rights, the logic of relativism goes on to say that different practices, interpretations, and implementation can be all equally correct. The different statuses of treaty acceptance, reservation, and practice may lead to the fact that different states are bound by different laws, so that they simply cannot legally judge each other. Human rights speak of what rights are inherent to humans, while cultural relativism assumes that there are no values inherent to human, only what is shaped by culture. This means that the concept of human in one culture is correct toward the humans adhering to that culture, while a different concept of humans is in another culture to the adherence of that other culture is equally correct, despite some items being possibly contradictory. So now, how actually we can reconcile between the two? I remember here Alison Stanton argument that if we want to reconcile, meaning to make friendly after estrangement, to show the compatibility of, to harmonize and yet maintain the integrity of, the conflict between cultural or ethical relativism and international human rights without being ethnocentric, we must, this is Alison said, look not simply for human rights case in the Western world, but for the humorphic equivalent for human rights in other societies. This means empirically supported cross-cultural universalists. It remains for us to continue the search for such cross-cultural universals so as to facilitate, in the words of Koba, an African human rights scholar, cross-cultural discussion and understanding of the ways by which different societies guarantee the dignity of their members. To argue that human rights are universal is not equivalent to saying that their understanding or interpretation is self-evident or immutable, or to denying the various cultural contexts in which human rights must be embedded. While rejecting radical cultural relativism does not preclude flexibility in the conceptualization, interpretation, and application of human rights within and between different cultures. Human rights are universal but not absolute, in the sense of pure, alloyed, completely uniform in their application to various cultures. So human rights are universal but not absolute in their application to various cultures. In this way, the relativist truth about enculturation can be accommodated within human rights framework. Relativist truth about enculturation can be accommodated within the human rights framework. And lastly, in my opinion, Islam is also a form of entity where the various cultures that surround it form a unity of truth, which in one particular cultural moment is considered as one truth. So it then might consider as universal truth. On another occasion, however, when the time has changed, the truth value may also undergo a change. That's all my presentation. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Professor Ratnul Lukito, for your presentation. And now we continue to the third presenter. We have
tahu.
Hello, Dr. Said Masud Nuri, can you hear me? Maybe there is trouble with
Yeah, hello.
Masud
Yeah,
Nuri's.
I have seen Dr. Said Masud Nuri. Maybe Mona can be louder.
Yeah, I see Masud Nuri and the participants here, but maybe there is some trouble with.
No, Masud Nuri is here. Maybe because it is unmute, he should unmute. Maybe the committee muted him, so he needs to unmute.
Okay, maybe we have to wait Dr. Said Masud Nuri for a while. And I see in the chat room, Professor Dr. Amina Wadud has a question for Professor Ratno Lukito. Why is culture, religion, particularly Islam, only defined by male persons? How can we have a conversation to reconcile between diverse cultures and the discourses over universal, not equally participated in by male and female persons per nation state? Professor Ratno Lukito, maybe you can answer this question, and then we will look for Masud Nuri then.
Thank you very much, Professor Amina Wadud. This is such a marvelous question, but I think it's not easy to answer. Yeah, but for me, as you said also before that, uh, male and female uh, are not the same. They are just the problem with us now is the access given to each of them are not the same. Yeah, the access is not the same. I think this is we just the the the, the culprit of the story that so far the
justice. It's my pleasure and honor to participate in such important event organized by Indonesian institution and colleagues. As the most populous Muslim country, Indonesia has a unique situation in the Muslim world, and in intellectual, cultural, and political relation between Muslims themselves and Muslims and non-Muslims. You maybe know that on average, more than 1 in 8 Muslims in the world living in Indonesia. I hope that the Indonesian elites, ulama, scholars, academics become more active in the intellectual leadership of Muslims and be a voice of non-violent and moderate Muslims, as the Holy Quran says, ummatan wasata. Let's think about the title of this conference: Islam, Human Rights and Legal Justice. 3 basic concepts that face complicated challenges today. If we don't say crisis. Islam, human rights, which include human dignity, and legal justice, which of course is, could be or should be a strong base for achieving the other aspects of justice, such as economic, social, gender, and environmental issues. Rejection of discrimination is one of the most fundamental concepts and foundation of Islam, as well as global human rights movement. In some area, this harmony between Islam and international human rights system is very clear. For example, anyone which has a little familiarity with Islam knows that in this religion, like international human rights system, it is clearly no place for any racial discrimination. But there are some questions about women, half of human population. Does Islam, specifically Islamic jurisprudence, fiqh, really believe in the equality of men and women? We all know that there are some cases among Islamic fatwas during the history that discriminate against challenging fatwa can be found in different areas, for example, marital relations and women inheritance. In this talk, I will focus on one of these issues, and I will try to show what solutions are available for this challenge. Work as judges, even in the Supreme Court. In the other part of Muslim world, women have some problem in this issue. Therefore, it is not a historical question related to the past fatwas. At least in some Muslim majority countries, it is a living issue and judgments as contemporary with Sharia. Women judges have also lost their jobs since the Taliban returned in power in Afghanistan about 3 months against their women or children's girls have been released. So, the question is that, is whether in Islam judgment is the inclusive right of man? Just man can be served the society as judges? Islam really said that women cannot serve as judge just because of their justice, even if they have all necessary conditions. We cannot and do not want to change the history of jurisprudence and present a false report. The fact is that through this history of Islamic jurisprudence, both in the Sunni and Shia schools, madhahib, most jurists have always said that being a man is one of the necessary conditions for holding a position of judge. And of course, a minority of fuqaha have always considered the reasons of that famous fatwa is as insufficient and have not accepted it. In the other words, during the history, the minority of jurists have allowed judgment for any qualified person, such as justice, sufficient knowledge, etc., regardless of his or her gender. But there are minority. Let's talk about majority of fuqaha and their fatwas. Among Sunni jurists, the Maliki, Shafi'i, and Hanbali fuqaha ulama consider being a man to be a condition of judgment. But of course, Abu Hanifa and Hanafi fuqaha have allowed women to judge just the property in a specific area that we permissible. So, is a minority. If you want to get more information about the very short report that I give you, you can see, for example, one of the most important works of late Zuhairi, the Syrian scholars, Al-Fiqh al-Islami wa-Adillatuh. He explained fatwas about all issues during the four major says being a male is one of the required qualification to be a judge. In some of his book, just like Al-Mabsud, and accepted the condition of being a man based on ijma. You know that ijma is one of the sources of fatwas. On the other hand, some jurists like Majlisi, Shaykh Ansari, and Muqaddas al-Dabili, and Mirza Qawmi rejected that ijma. They say that we don't have ijma about it. There is different ideas, different fatwas, so there is no ijma. And they say that the evidence of condition of being man to judge is not necessarily valid. In the contemporary period, our time, some jurists, Shia jurists in Najaf, that like a majority of jurists, they believe that for being a judge, you should be a man. But at the same time, some grand ayatollahs like Sayyid Ahmad Ansari and Musavi al-Dabili and Sani, they say that no, the reason is not enough strong. So, generally speaking, fuqaha have listed requirements, qualification for a judge, such as being a mutual, so children cannot be appointed as a judge, it is very clear, and wise, and having faith, and fair, justice, adala, and absolute ijtihad. I will refer to this point as well. Absolute ijtihad, and being a man. But one of the most famous documents of Shia jurists for the necessity of being a man for a judge is a hadith, which says, you know, is one of the important hadiths that man. Okay? The hadith is that إياكم أن يحاكم بعضكم بعضا إلى أهل الجور. I'm sure that some of you know Arabic, so I refer to the text of a hadith, and after that it's English translation. إياكم أن يحاكم بعضكم إلى بعضكم بعضا إلى أهل الجور، ولكن انظروا إلى رجل منكم يعلم شيئا من قضايانا فاجعلوه بينكم فإني قد جعلته قاضيا فتحاكموا إليه. Muhammad ibn Yaqub. The story is that someone asked Imam Sadiq what we should do when a dispute raises between us people. Can we refer to the judges appointed by the corrupt rulers, by Taghut, Hakim Zalim? Can we refer to those judges? This hadith forbids the answer to this question. Found a man, agreed to refer to him. I, as an imam, appointed him as a judge. Okay? So, Fuqaha says that because of the word man, rajul, it means we understand that we cannot refer to a woman. Judge should be a man. But there is another understanding, which is the word rajul doesn't mean a man. Rajul has, in Arabic, rajul has two meanings. Yeah, one, man against women. And second is a figure. The person, the society knows him or her. Okay, the figure. So maybe, and this hadith, I told you that I will refer to this point as again, knows our ahkam. It means that the fuqaha says that it means that judge should be a mujtahid, a faqih. We cannot refer to somebody as a judge who don't know anything or have a very little Islamic jurisprudence. We should refer to mujtahid, to mufti, who knows the Sharia, who knows the jurisprudence. So this is what Shia jurists understand from this hadith. Two things. Judge should be a mujtahid and judge should be a man, because Imam says rajul. Okay? Or the problem, they say rajal. But at the same time, when they say this is a rajul, this is a book in rajal, in knowledge of knowing the although the name is Rajal, we have some information about women as well. So Rajal in this case means figures, well-known person, not just women. This is one solution. The other solution, which is more important, is that we should be careful and pay attention that we have two kind of judgment. Judgment based on Sharia, judgment based on law. Before our time, I mean nation state time, all judgment happened by fuqaha, by their fatwas. If somebody, a group of people or two of people have some dispute, comes to me as a mufti, and I judge between them based on my understanding. Because of that, they say that judge should be a mufti, a faqih. Okay? But in our times, judgment is based on what the parliament passed, positive law, not Sharia. I don't want to say that Sharia and law is different or in opposite to each other. No, sometimes they are the same, sometimes they are different. But even sometimes the decision in the court because of the ijtihad, or because Abu Hanifa says or Imam Shafi'i says. No, I'm in the court refer to the civil code or other codes of law. So in this case, we have different judgments. Judgment based on Sharia. Okay, in this category, we says that judge should be man, judge should be mujtahid, and other qualification, necessary qualification. But in our times, that we living in the nation state, judgments are based on positive law. There is no need to refer to that qualification. So, as a last point, I want to say that even in Islamic Republic of Iran, which says that the Constitution in Article 4 and other articles says that everything should be based on Sharia. At the same time, imagine this case that I am a mujtahid, I'm a judge. My fatwas is different as what the parliament says, the positive law says. Can I make my decision in court based on my fatwa? The law says no, you can't. Even you are mujtahid, you should follow the law. But because I cannot decide against my fatwa, I should refer the case to other branches, other courts. It means that if I am a mujtahid, because at our times, judgment is not based on Sharia, is based on positive law, I cannot follow my understanding, my fatwa, my personal understanding of Islamic Sharia. I should refer the case to other court. It means that everything should be everything in the court should follow the law by parliament, passed by parliament. So, in this situation, there is no problem, should be a judge, not mujtahid, and not judgment based on positive law and what the parliament passed. There is no necessary to judge for being a man or woman. There is no difference between them. So I want to say that we can find some solution even in the framework of Sharia to make more harmonized between Islam, between our understanding of Islam and human rights law system. Of course, always there is some dispute, some different understanding, and even some problem, but we should and we could solve some of them, if not all of them. Thank you so much. Thank you for your patience, and hopefully at least some good points in my presentation be for you. Thank you so much. Thank you for your patience, and God bless all of you and your works. Bismillah.
Okay, thank you so much, Dr. Syed Masud Nuri, for your video presentation. What a pity that we can listen to this very good person of the trouble of the connection, so we can't do anything about it. But thank you so much for your video, sir. Okay, it's already 10 past 26 a.m. now. I'm afraid I have to close this session. But before that, we will have some certificates for the two presentators. First one is for Professor Ratno Lokito. This certificate similarly for on behalf of you, Professor Ratno, and then we will deliver the certificate to your hand.
Thank you so much.
Thank you so much, Professor. And the second certificate is for Dr. Syed Masud Nuri. Again, please let me accept the certificate simultaneously for you, and then we will deliver the certificate to your hand. Thank you so much for all presenters and participants in this session. Professor Dr. Amina Wadud, Professor Dr. Andes Haji Ratno Lokito, MADCL, and Dr. Syed Masud Nuri. But before I close this session, we will take some pictures. Please, Professor Amina, Professor Ratno, Dr. Masud, Professor Ais, Dr. Sri Wahyuni, can you turn on your camera for a while so we can take some pictures? Please wait for a while.
Smiling professor. Sudah?
Wait for a while, Professor. Okay. So let's take some pictures now. Okay, one. Okay, more picture. Okay, thank you so much for you all. And maybe for the participants here who want to take some pictures, you can turn on your camera for a while. Okay. For all the participants, you can turn on your camera. Okay, thank you so much for all the participants here. Now I have to close. Now I have to close this first session of plenary session, and right after this at 10:30 a.m. we will have the second plenary session. So please remain here, and we will be back soon. Assalamualaikum warahmatullahi wabarakatuh.
Keluarga Islam merupakan salah satu program studi Fakultas Syariah dan Hukum Universitas Islam Negeri Sunan Kalijaga Yogyakarta dengan peringkat akreditasi A. Program studi hukum keluarga Islam ini sendiri dalam sejarahnya adalah pengembangan dari jurusan Qadha dan Peradilan Agama yang ketika itu masih bersatu sebagai Institut Agama Islam Negeri atau IAIN. Program studi hukum keluarga Islam awalnya bernama Ahwal Syakhsiyah sebelum mendapatkan pengindonesiaan nama pada tahun 2016. Program studi hukum keluarga Islam mempunyai visi untuk menjadi program studi yang unggul dan terkemuka dalam pemaduan dan pengembangan ilmu hukum keluarga Islam atau ahwal syakhsiyah bagi peradaban. Untuk merealisasikan visi tersebut, maka misi yang harus dilakukan oleh program studi hukum keluarga Islam adalah sebagai berikut. 1. Mengembangkan pendidikan dan pengajaran dalam bidang ilmu hukum keluarga Islam secara integratif dan interkonektif. 2. Mengembangkan budaya riset dalam bidang ilmu hukum keluarga Islam secara multidisipliner. 3. Meningkatkan peran serta program studi dalam pemberdayaan masyarakat melalui penerapan ilmu hukum keluarga Islam. 4. Mengembangkan hukum keluarga Islam dengan berbagai pihak untuk meningkatkan kualitas pelaksanaan Tridharma perguruan tinggi. Untuk menghasilkan sarjana ilmu hukum keluarga Islam atau ahwal syakhsiyah yang memiliki kemampuan akademik secara profesional dan berakhlak mulia, maka program studi hukum keluarga Islam menerapkan metode pembelajaran yang integratif dan interkonektif pada produk dan praktik keilmuannya. Pada produk keilmuan, mencoba mengintegrasi dan menginterkoneksikan antara ilmu umum dan ilmu agama, sehingga selain menguasai ilmu hukum keluarga, mahasiswa juga menguasai berbagai ilmu agama Islam. Selanjutnya adalah integrasi dan interkoneksi praktik keilmuan antara pengalaman ilmu di lingkungan kampus dan praktik profesi di berbagai instansi hukum. Di antaranya, praktik kuliah lapangan atau PKL di lingkungan kantor urusan agama atau KUA dan praktik peradilan di pengadilan agama dan pengadilan negeri. Mahasiswa program studi hukum keluarga Islam selalu diarahkan untuk memiliki kompetensi akademik yang profesional.
Oke.
Woi. Itu pengen sholat apa? Halo guys. Halo juga.
Dia belum ya, soalnya dari Bu Sri.
Kecakapan sosial, manajerial, dan berjiwa mandiri. Dengan gelar akademik sebagai sarjana hukum, mahasiswa lulusan program studi hukum keluarga Islam
Cek 1, 2, 3.
Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah. Welcome to the second plenary session of the 5th Annual International Conference on Law and Sharia, ICOLS. In this session, I'm going to be the moderator of this session. And the conference is about practice of Islamic family law and Islamic legal system. And we already, first speaker is Professor Ais Nurelawati. She is from State Islamic University, Sunan Kalijaga Yogyakarta. And the second speaker is Dr. Kamila Ibrahim from International Islamic University, Malaysia, IAUM. And the third speaker is Associate Professor Dr. Nadia Sonoval from Leiden University. So, ladies and gentlemen, before we start this session, I would like to open a discussion, or maybe there is a question from participant to Dr. Syed Mas'ud Nuri. Yeah. If there is any question or comment from the presentation of Dr. Syed Mas'ud Nuri, please to write in the chat room. Yeah. Because Dr. Syed Mas'ud Nuri, he only can answer the question in chat room. Yeah. Okay. And now we going to the session for the first presenter. We have Professor Dr. Ais Nurelawati. She will talk about Islamic family law and human rights changes through judicial review in Indonesia. Hello, Professor Ais Nurelawati. Can we hear your voice? Professor Ais.
Halo, Assalamualaikum warahmatullahi wabarakatuh. Thank you.
Okay, Professor Ais Nurelawati will speak about Islamic family law and human rights changes through judicial review in Indonesia. I will give Professor Ais 20 minutes for presentation. Okay, time is yours, Professor.
Okay. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you very much. I suddenly forgot your name. So sorry. Okay, thank you very much. First of all, I would like to thank the committee for having organized this conference and for having me for this session. I'm very grateful that we came to the Islamic Sharia and for this opportunity, and I would like to take the opportunity to thank my colleagues, Professor Nadia Sonoval, Professor Kamila Ibrahim, and Professor Syed Mas'ud Nuri for having accepted our invitation to be presenting papers in this conference. I'm going to talk about the development of Muslim family law in Indonesia, and I will consider judicial reviews. And with this, I would like to argue that human rights and Islamic values are still debated within Muslim family law discourse in Indonesia and within Muslim family law practices in Indonesia. My presentation will be divided into 4 parts. The first part is the introduction, which is being done now by me, and the second part focuses I think the committee has already said this, but I think it will be easier for me to manage the PowerPoint, so I would like to share it by myself. Okay, all right. Okay, thank you. This is my PowerPoint. I'm so sorry I have stopped the screen sharing of the committee because I think it's easier for me to manage my PowerPoints. Well, when we talk about family law, we have to mention the first law of marriage, number 1, 1974. This is, as we acknowledge, the national law, and this applies to all citizens regardless of their religions or Indonesian citizens under to this law, and in some cases of family. And this law of marriage covers only marriage, and the law has like legal status on a number of family issues. And for this, then there were seminars held by gender activists to questions about the legal status of them.
2 minutes left, Prof. I'm sorry. Okay, thank you, Prof. Aisinur Lawati, for your for your presentation. And now we continue to the second speaker, Dr. Kamila Ibrahim. She is from International Islamic University Malaysia, and she will speak about justice and realization of Sharia nafkah orders after divorce, mechanism and institution in Malaysia. Okay, Dr. Kamila, time is yours. Waalaikumsalam warahmatullahi wabarakatuh.
For example, if a husband was not fulfilling his duty to provide financial maintenance to the wife, then she could ask for a divorce. And there were a few more reasons. My intention here is not to go into the details of every divorce ground, because that would take up too much time which I don't have the slides with you later on, if that's something you would like to want, something you want. So in 1920 and again in 1929, the divorce grant. In 1929, for example, harm or worse for COVID, and that was not always easy. Coptic men and women were lagging a little bit behind, but the spirit of liberation also had set in, and in 10 years later, the divorce grants for Coptic men and women. A council called the Maclisantes. So let me move to the next slide. So here, for both Muslim women and Coptic men and women, the divorce grants have considerably expanded. Yeah, so for example, in the case of Muslim women, if the husband disappears, first she had to wait, according to Hanafi understandings, for 90 years before she could get a divorce. So that basically meant that she had to wait until until it was very certain that her husband had died. And now, after a year, she could already ask for a court divorce. And if we look at Coptic men and women, then we see absence is also included as a ground, imprisonment, mental illness, joining a monastic order, and the list goes on. And as I told you, it's not my intention here to go through the list extensively. But just looking at it, you can see there have been added so many grounds. An important legal change happened in the 1950s when ex-president Gamal Abdel Nasser came to power, and he wanted to nationalize, agriculture, everything basically in the country. So also the legal system. Yeah, and to get rid of that Ottoman legacy, he decided to change the procedural laws, not, and that's very important, the substantive laws on family, personal status law or family law. So what happened was that the religious courts were abolished, and I think quite a few of you know that, but the content of the different family laws for Muslims, for Christians, and for Jews, that was kept intact. That was not changed. So, because of the procedural changes, you see that alimony, child custody, guardianship, and inheritance, and please keep the inheritance in mind for later on. In all these cases, Muslim family law would apply. So even if the partners would be from the same Christian denomination. If the spouses were of different denominations, for example, the husband is Coptic and the wife is Protestant, would apply. And for the Copts, the Majlis al-Milli was also eradicated. So there was no lay council representing the Copts anymore, only religious authorities. Yeah, and you probably know this too, maybe not in detail, but the 1970s, again, after ex-president Gamal Abdel Nasser had passed away and was succeeded by Sadat. Sadat was also a very turbulent period in Egyptian history. And how does that reflect on the development of family law in Egypt? Well, first of all, it's important now to start paying attention to the Egyptian constitution, because a very important and long-lasting change was introduced by al-Sadat. Article 2 of the constitution came to state that the principles of Islamic Sharia are a main source of legislation. And in the same year, just a few months later, the Coptic Pope, by then Shenouda, he reacted. He was elected and he reacted promptly. Yeah, so he was reducing the divorce grounds from like 10 or something to back to zina, adultery, and apostasy again. So back to 2 grounds only. And there was no Coptic community council, so no lay council who could represent the common Copts in front of the religious authorities. So it just happened, and it became very difficult for Coptic persons to divorce. With the result that many changed their denomination, because if you remember from the last slide, are from different denominations, then Islamic family law will apply. And in that case, you can ask for a divorce, both men, talaq, and women, on the basis of the new divorce grounds that were introduced in the 1920s. Because mind you, for Muslim women, after the 1920s until the 1970s, nothing changed. In 1980, there was an important constitutional change again, because Article 2 now came to state that the principles of Islamic Sharia are the main source of legislation. And you would say that that might lead to conservative changes being introduced, especially in the field of family law, because after all, that's it's not just a field of law, it's a very symbolic field of law in terms of Islamic identity. But the changes that were proposed in the 1970s, they were all, they were very progressive, but they were refuted. Also because the president, Al-Sadat, had introduced them in a period of parliamentary recess, while there was no emergency situation that could justify that. So, but then in the 2000s, January 2000, it finally happened. Muslim family law was reformed. Yeah, and here you see the first and most important change was the introduction of a divorce for women called khola. And in the Egyptian case, it's a non-consensual, no-fault divorce. The wife does not need the permission of her husband, and she also does not need to show in court that she has good legal reasons for the divorce. The only thing she needs to do is to declare in front of the judges that she hates living with her husband, and that she is afraid that she will transgress the borders of her religion were she to stay in that marriage. And of course, she also has to pay back the mahar, the dower. And there is a lot to say about it. I mean, I actually wrote a book about it, but there is no time for it now. What I briefly would like to point out is that children's custody rates, they also changed. And as you remember from the changes in the 1950s under Gamal Abdel Nasser, custody was an area or a situation in which there were no differences between Muslims and Christians. So 15 years for both boys and girls in case of divorce. Until the age of 15, they would stay with the mother. And well, for the sake of time, I just move on, because also the Coptic law changed in 2008. The Coptic Community Council was brought back into action, but it was a kind of symbolic, because instead of representing the interest of Coptic lay persons who had in asking, because the Christian churches in Egypt had made it very difficult for people to change denomination. So it was becoming increasingly difficult to change from Coptic Christianity to Catholicism, for example, only for the sake of getting a divorce. So in these cases, people had to convert to Islam, which quite a number of people were actually doing. Asking for more liberal divorce laws, and despite the fact that many people were changing religion, the religious authorities insisted on keeping the grounds for divorce very limited, and also the Coptic Community Council, it officially amends the 1938 code. Yeah, so the code that gave so many grounds for divorce, and now only divorce was allowed in case of adultery and apostasy. Yeah, so this was also meant to mean that the judges who would apply all these changes, and most the cases coming in front of civil courts, most of these judges are secular trained judges, and most of them are Muslim. They have an Islamic background. So these judges were supposed to only allow divorce in cases of adultery and apostasy, which sometimes happened and sometimes did not happen. Yeah, I'm about, if that was the issue. As you can see, Article 2 did not change, in the sense that the principles of Islamic Sharia are still the principal source of legislation. There was a new article introduced, and that's the church was constitutionally designated a guardian of Christians, constitutionally, because in practice it had been the guardian of Christians in matters of personal status law for some. And now this can work out two ways. And because it contradicted the Islamic Sharia, and it turned Copts into second-ranking citizens. Actually, again, the introduction of Article 3. And they wanted to return to the pre-revolutionary period. But it just to change the divorce laws. But on the same hand, at the same time, it was also confronted with a lot of Coptic persons, demanding that a change would be introduced. Functional marriages. Yeah, so the Coptic Church program on TV, in which a member of parliament, a Coptic member of parliament, announced a new unified, and they had come up with a draft to expand the divorce grounds and the inheritance grounds for front of parliament. And as most of you probably know, if the Egyptian parliament has to vote on it, then it will vote on it. So people are very confident that this law will receive equal shares. And this, according to the member of parliament who introduced these changes to the public, he said this was only possible after the introduction of Article 3 in the Constitution of 2014. So here we see of such a new article in the Constitution can work two ways. In this case, it now works out this way. And this is what I wanted to share with you on this morning, and I look forward. I hope you found it interesting, and I look forward to questions, suggestions, remarks, and thank you very much for your attention.
Thank you, Dr. Thank you, Dr. Nadia Sonevel, for your presentation. And now I will open session for discussion. So we have time until 12:20. So 15 minutes for discussion. I will give 3 person or the 3 per participant to ask question for the 3 speakers. So maybe there is someone who has a question or want to comment from the presentation.
We have 151 participants.
Yes.
And nobody
And no
has a question.
A question for Dr. Nadia.
Okay, Profesor Ratno kita.
For Dr. Nadia. Thank you very much for Dr. Nadia. Can there now be say that for Coptic denomination or Christian people in general in Egypt have better condition now, that they will have a new law for them that can apply their own law, or is there any ways to apply that law, something like that? And the second thing is, what is the problem for the government to give access to
the question?
Yes. Thank you, Professor Ratno Lupito, for your questions. As for the first question, you have to repeat it because I did not write it down quick enough. The Egyptian government who makes Christians convert to Islam in order to get a divorce, it's a problem within the Christian communities inside Egypt. So where in the past it was possible to change your denomination and have Islamic law be applied to you, this no longer is the case. So if you, for example, are a Coptic Christian man and you want to change to Catholicism, then the Catholic Church will only allow you to change your religion inside Egypt after a period of like a year, maybe, sometimes a little bit less, in which they will really test your knowledge about
this SIMKA, system. What is the SIMKA? Thank you very much. Thank you.
Okay, thank you, Professor S, for you. But before I close the session, maybe we can take picture. Oh, giving certificate for speakers from the Sharia and Law Faculty of UIN Sunan Kalijaga. Symbolic
To Prof. Dr. Nadia Sonevos. Nadia Sonevos. Next, Prof. Uwais Nurlailawati, MA PhD.
I'm not really hearing what was being said.
Okay, thank you. Give applause for Professor Dr. Uwais. And then Dr. Kamila. Give applause.
One, two, three. One more. Okay, thank you for all presenter and participant in this session. See you in other conference. Assalamualaikum warahmatullahi wabarakatuh.
Warahmatullahi wabarakatuh. Thank you, Professor Nadia.
Yeah, thank you, dear colleagues. Hope to see you soon again.
Professor
Thank you
Camilla.
very much.
Miss
Puan,
Thank
Puan
you,
Dr. Camelia, Dr. Nadia. I am Dr. Sri Wahyuni, the Vice Dean of Sharia and Law Faculty. We say thank you very much for you all for coming here, for joining the conference. Thank you very much.
Thank you. It was a pleasure.
Yeah, thank you very much. Thank you, Prof. Ois.
Thank you very much.
Thank you very much.
Thank you, Prof. Camelia Ibrahim.
Thank you very much. Thank you very much, everybody. Assalamualaikum.
Waalaikumsalam.
Salam. Thank you for Dr. Camelia. And for all participants, that the next session at the 1 p.m. We will start the
Thank you for everyone. Forgive me for my mistake and the next second. Thank you for everyone for coming. I course. Forgive me for my mistake and the next second. 1 o'clock. And on time, please.
Masih Bu Yuni. Sampai nanti.
ya, makasih Prof. Alhamdulillah. Aduh, yang pertama tadi yang menegangkan. Belum pada bisa masuk Zoom tadi. Oke, makasih semuanya. Nanti kita kumpul lagi jam 1 ya.
Ya, tadi juga saya kontak Ibu Nadia itu melalui email, bolak-balik dicek email, makanya pas bagian presentasi udah udah gugup. mikirin takutnya hadir Ibu Nadia.
Sama tadi itu Prof. Ami masuk Zoom jadi ada.
Makanya tadi udah kontak-balik. Saya diberi nomor handphone oleh Nadia, tapi saya nggak bisa kontak, nggak tahu nggak masuk terus, pokoknya gagal terus. Mungkin saya menyimpannya yang salah, kan dia luar negeri itu Bu Yuni. Jadi ngerti. Akhirnya buka email bolak-balik mengontak dia via email. Alhamdulillah bisa nyambung dan dia bilang sebentar lagi. Pagi-pagi anaknya masih harus ngurus anak. Ya tapi alhamdulillah lah semuanya bisa.
Akan diberikan besok ya. Besok masih ada rangkaian acara untuk diikuti lagi. Sertifikat akan dibagi besok.
Hukum Keluarga Islam merupakan salah satu program studi Fakultas Syariah dan Hukum Universitas Islam Negeri Sunan Kalijaga Yogyakarta dengan peringkat akreditasi A. Program studi Hukum Keluarga Islam ini sendiri dalam sejarahnya adalah pengembangan dari jurusan Qadha dan Peradilan Agama yang ketika itu masih bersatu sebagai Institut Agama Islam Negeri atau IAIN. Program studi hukum keluarga Islam awalnya bernama Ahwal Syakhsiyah sebelum mendapatkan pengindonesiaan nama pada tahun 2016. Program studi hukum keluarga Islam mempunyai visi untuk menjadi program studi yang unggul dan terkemuka dalam pemaduan dan pengembangan ilmu hukum keluarga Islam atau Ahwal Syakhsiyah bagi peradaban. Untuk merealisasikan visi tersebut, maka misi yang harus dilakukan oleh program studi hukum keluarga Islam adalah sebagai berikut. 1. Mengembangkan pendidikan dan pengajaran dalam bidang ilmu hukum keluarga Islam secara integratif dan interkonektif. 2. Mengembangkan budaya riset dalam bidang ilmu hukum keluarga Islam secara multidisipliner. 3. Meningkatkan peran serta program studi dalam pemberdayaan masyarakat melalui penerapan ilmu hukum keluarga Islam. 4. Mengembangkan jaringan kerjasama program studi hukum keluarga Islam dengan berbagai pihak untuk meningkatkan kualitas pelaksanaan Tridharma perguruan tinggi. Untuk menghasilkan sarjana ilmu hukum keluarga Islam atau Ahwal Syakhsiyah yang memiliki kemampuan akademik secara profesional dan berakhlak mulia, maka program studi hukum keluarga Islam menerapkan metode pembelajaran yang integratif dan interkonektif pada produk dan praktik keilmuannya. Pada produk keilmuan, mencoba mengintegrasi dan menginterkoneksikan antara ilmu umum dan ilmu agama sehingga praktik keilmuan antara pengalaman ilmu di lingkungan kampus dan praktik profesi di berbagai instansi hukum. Di antaranya, praktik kuliah lapangan atau PKL di lingkungan kantor urusan agama atau KUA dan praktik peradilan di pengadilan agama dan pengadilan negeri. Mahasiswa program studi hukum keluarga Islam selalu diarahkan untuk memiliki kompetensi akademik yang profesional, berakhlak mulia, memiliki kecakapan sosial, manajerial, dan berjiwa mandiri. Dengan gelar akademik sebagai sarjana hukum, mahasiswa lulusan program studi hukum keluarga Islam sangat berpeluang untuk mengisi berbagai bidang. Di antaranya, hakim pada pengadilan agama dan umum, advokat, konsultan hukum di pengadilan agama, peneliti, dan tentunya masih banyak lagi profesi yang dapat dilakukan oleh para lulusan program studi hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga Yogyakarta. Akhirnya, program studi hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga akan terus berkomitmen untuk mencetak lulusan dengan Hukum Keluarga Islam merupakan salah satu program studi Fakultas Syariah dan Hukum Universitas Islam Negeri Sunan Kalijaga Yogyakarta dengan peringkat akreditasi A. Program studi Hukum Keluarga Islam ini sendiri dalam sejarahnya adalah pengembangan dari jurusan Qadha dan Peradilan Agama yang ketika itu masih bersatu sebagai Institut Agama Islam Negeri atau IAIN. Program studi Hukum Keluarga Islam awalnya bernama Ahwal Syakhsiyah sebelum mendapatkan pengindonesiaan nama pada tahun 2016. Program studi Hukum Keluarga Islam mempunyai visi untuk menjadi program studi yang unggul dan terkemuka dalam pemaduan dan pengembangan ilmu hukum keluarga Islam atau Ahwal Syakhsiyah bagi peradaban. Untuk merealisasikan visi tersebut, maka misi yang harus dilakukan oleh program studi hukum keluarga Islam adalah sebagai berikut. 1. Mengembangkan pendidikan dan pengajaran dalam bidang ilmu hukum keluarga Islam secara integratif dan interkonektif. 2. Mengembangkan budaya riset dalam bidang ilmu hukum keluarga Islam secara multidisipliner. 3. Meningkatkan peran serta program studi dalam pemberdayaan masyarakat melalui penerapan ilmu hukum keluarga Islam. 4. Mengembangkan jaringan kerjasama program studi hukum keluarga Islam dengan berbagai pihak untuk meningkatkan kualitas pelaksanaan Tridharma perguruan tinggi. Untuk menghasilkan sarjana ilmu hukum keluarga Islam atau Ahwal Syakhsiyah yang memiliki kemampuan akademik secara profesional dan berakhlak mulia, maka program studi hukum keluarga Islam menerapkan metode pembelajaran yang integratif dan interkonektif pada produk dan praktik keilmuannya. Pada produk keilmuan, mencoba mengintegrasi dan menginterkoneksikan antara ilmu umum dan ilmu agama, sehingga selain menguasai ilmu hukum keluarga, mahasiswa juga menguasai berbagai ilmu agama Islam. Selanjutnya adalah integrasi dan interkoneksi praktik keilmuan antara pengalaman ilmu di lingkungan kampus dan praktik profesi di berbagai instansi hukum. Di antaranya, praktik kuliah lapangan atau PKL di lingkungan kantor urusan agama atau KUA dan praktik peradilan di pengadilan agama dan pengadilan negeri. Mahasiswa program studi hukum keluarga Islam selalu diarahkan untuk memiliki kompetensi akademik yang profesional, berakhlak mulia, memiliki kecakapan sosial, manajerial, dan berjiwa mandiri. Dengan gelar akademik sebagai sarjana hukum, mahasiswa lulusan program studi hukum keluarga Islam sangat berpeluang untuk mengisi berbagai bidang. Di antaranya, hakim pada pengadilan agama dan umum, advokat, konsultan hukum di pengadilan agama, peneliti, dan tentunya masih banyak lagi profesi yang dapat dilakukan oleh para lulusan program studi hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga Yogyakarta. Akhirnya, program studi hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga akan terus berkomitmen untuk mencetak lulusan dengan keahlian profesi, tetapi memiliki basis pengetahuan, sosial, dan spiritual yang matang, sehingga penyerapan alumni tidak hanya bergerak secara spesifik dalam bidang hukum saja, tetapi juga meluas di bidang-bidang lainnya sesuai dengan kebutuhan zaman. Kami berkomitmen untuk itu. Mengabdi untuk kebanggaan negeri. Hukum Keluarga Islam merupakan salah satu program studi Fakultas Syariah dan Hukum Universitas Islam Negeri Sunan Kalijaga Yogyakarta dengan peringkat akreditasi A. Program studi Hukum Keluarga Islam ini sendiri dalam sejarahnya adalah pengembangan dari jurusan Qadha dan Peradilan Agama yang ketika itu masih bersatu sebagai Institut Agama Islam Negeri atau IAIN. Program studi Hukum Keluarga Islam awalnya bernama Ahwal Syakhsiyah sebelum mendapatkan pengindonesiaan nama pada tahun 2016. Program studi Hukum Keluarga Islam mempunyai visi untuk menjadi program studi yang unggul dan terkemuka dalam pemaduan dan pengembangan ilmu hukum keluarga Islam atau Ahwal Syakhsiyah bagi peradaban. Untuk merealisasikan visi tersebut, maka misi yang harus dilakukan oleh program studi hukum keluarga Islam adalah sebagai berikut. 1. Mengembangkan pendidikan dan pengajaran dalam bidang ilmu hukum keluarga Islam secara integratif dan interkonektif. 2. Mengembangkan budaya riset dalam bidang ilmu hukum keluarga Islam secara multidisipliner. 3. Meningkatkan peran serta program studi dalam pemberdayaan masyarakat melalui penerapan ilmu hukum keluarga Islam. 4. Mengembangkan jaringan kerjasama program studi hukum keluarga Islam dengan berbagai pihak untuk meningkatkan kualitas pelaksanaan Tridharma perguruan tinggi. Untuk menghasilkan sarjana ilmu hukum keluarga Islam atau Ahwal Syakhsiyah yang memiliki kemampuan akademik secara profesional dan berakhlak mulia, maka program studi hukum keluarga Islam menerapkan metode pembelajaran yang integratif dan interkonektif pada produk dan praktik keilmuannya. Pada produk keilmuan, mencoba mengintegrasi dan menginterkoneksikan antara ilmu umum dan ilmu agama, sehingga selain menguasai ilmu hukum keluarga, mahasiswa juga menguasai berbagai ilmu agama Islam. Selanjutnya adalah integrasi dan interkoneksi praktik keilmuan antara pengalaman ilmu di lingkungan kampus dan praktik profesi di berbagai instansi hukum. Di antaranya, praktik kuliah lapangan atau PKL di lingkungan kantor urusan agama atau KUA dan praktik peradilan di pengadilan agama dan pengadilan negeri. Mahasiswa program studi hukum keluarga Islam selalu diarahkan untuk memiliki kompetensi akademik yang profesional, berakhlak mulia, memiliki kecakapan sosial, manajerial, dan berjiwa mandiri. Dengan gelar akademik sebagai sarjana hukum, mahasiswa lulusan program studi hukum keluarga Islam sangat berpeluang untuk mengisi berbagai bidang. Di antaranya, hakim pada pengadilan agama dan umum, advokat, konsultan hukum di pengadilan agama, peneliti, dan tentunya masih banyak lagi profesi yang dapat dilakukan oleh para lulusan program studi hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga Yogyakarta. Akhirnya, program studi hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga akan terus berkomitmen untuk mencetak lulusan dengan keahlian profesi, tetapi memiliki basis pengetahuan, sosial, dan spiritual yang matang, sehingga penyerapan alumni tidak hanya bergerak secara spesifik dalam bidang hukum saja, tetapi juga meluas di bidang-bidang lainnya sesuai dengan kebutuhan zaman. Kami berkomitmen untuk itu. Mengabdi untuk kebanggaan negeri. Keluarga Islam merupakan salah satu program studi Fakultas Syariah dan Hukum Universitas Islam Negeri Sunan Kalijaga Yogyakarta dengan peringkat akreditasi A. Program studi hukum keluarga Islam ini sendiri dalam sejarahnya adalah pengembangan dari jurusan Qadha dan Peradilan Agama yang ketika itu masih bersatu sebagai Institut Agama Islam Negeri atau IAIN. Program studi hukum keluarga Islam awalnya bernama Ahwal Syakhsiyah sebelum mendapatkan pengindonesiaan nama pada tahun 2016. Program studi hukum keluarga Islam mempunyai visi untuk menjadi program studi yang unggul dan terkemuka dalam pemaduan dan pengembangan ilmu hukum keluarga Islam atau ahwal syakhsiyah bagi peradaban. Untuk merealisasikan visi tersebut, maka misi yang harus dilakukan oleh program studi hukum keluarga Islam adalah sebagai berikut. 1. Mengembangkan pendidikan dan pengajaran dalam bidang ilmu hukum keluarga Islam secara integratif dan interkonektif. 2. Mengembangkan budaya riset dalam bidang ilmu hukum keluarga Islam secara multidisipliner. 3. Meningkatkan peran serta program studi dalam pemberdayaan masyarakat melalui penerapan ilmu hukum keluarga Islam. 4. Mengembangkan jaringan kerjasama program studi hukum keluarga Islam dengan berbagai pihak untuk meningkatkan kualitas pelaksanaan Tridharma perguruan tinggi. Untuk menghasilkan sarjana ilmu hukum keluarga Islam atau ahwal syakhsiyah yang memiliki kemampuan akademik secara profesional dan berakhlak mulia, maka program studi hukum keluarga Islam menerapkan metode pembelajaran yang integratif dan interkonektif pada produk dan praktik keilmuannya. Pada produk keilmuan, mencoba mengintegrasi dan menginterkoneksikan antara ilmu umum dan ilmu agama, sehingga selain menguasai ilmu hukum keluarga, mahasiswa juga menguasai berbagai ilmu agama Islam. Selanjutnya adalah integrasi dan interkoneksi praktik keilmuan antara pengalaman ilmu di lingkungan kampus dan praktik profesi di berbagai instansi hukum. Di antaranya, praktik kuliah lapangan atau PKL di lingkungan kantor urusan agama atau KUA dan praktik peradilan di pengadilan agama dan pengadilan negeri. Mahasiswa program studi hukum keluarga Islam selalu diarahkan untuk memiliki kompetensi akademik yang profesional, berakhlak mulia, memiliki kecakapan sosial, manajerial, dan berjiwa mandiri. Dengan gelar akademik sebagai sarjana hukum, mahasiswa lulusan program studi hukum keluarga Islam sangat berpeluang untuk mengisi berbagai bidang. Di antaranya, hakim pada pengadilan agama dan umum, advokat, konsultan hukum di pengadilan agama, peneliti, dan tentunya masih banyak lagi profesi yang dapat dilakukan oleh para lulusan program studi hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga Yogyakarta. Akhirnya, program studi hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga akan terus berkomitmen untuk mencetak lulusan dengan keahlian profesi, tetapi memiliki basis pengetahuan, sosial, dan spiritual yang matang, sehingga penyerapan alumni tidak hanya bergerak secara spesifik dalam bidang hukum saja, tetapi juga meluas di bidang-bidang lainnya sesuai dengan kebutuhan zaman. Kami berkomitmen untuk itu. Mengabdi untuk kebanggaan negeri. Keluarga Islam merupakan salah satu program studi Fakultas Syariah dan Hukum Universitas Islam Negeri Sunan Kalijaga Yogyakarta dengan program studi hukum keluarga Islam ini sendiri dalam sejarahnya adalah pengembangan dari jurusan Qadha dan Peradilan Agama yang ketika itu masih bersatu sebagai Institut Agama Islam Negeri atau IAIN. Program studi hukum keluarga Islam awalnya bernama Ahwal Syakhsiyah sebelum mendapatkan pengindonesiaan nama pada tahun 2016. Program studi hukum keluarga Islam mempunyai visi untuk menjadi program studi yang unggul dan terkemuka dalam pemaduan dan pengembangan ilmu hukum keluarga Islam atau ahwal syakhsiyah bagi peradaban. Untuk merealisasikan visi tersebut, maka misi yang harus dilakukan oleh program studi hukum keluarga Islam adalah sebagai berikut. 1. Mengembangkan pendidikan dan pengajaran dalam bidang ilmu hukum keluarga Islam secara integratif dan interkonektif. 2. Mengembangkan budaya riset dalam bidang ilmu hukum keluarga Islam secara multidisipliner. 3. Meningkatkan peran serta program studi dalam pemberdayaan masyarakat melalui penerapan ilmu hukum keluarga Islam. 4. Mengembangkan jaringan kerjasama program studi hukum keluarga Islam dengan berbagai pihak untuk meningkatkan kualitas pelaksanaan Tridharma perguruan tinggi. Untuk menghasilkan sarjana ilmu hukum keluarga Islam atau ahwal syakhsiyah yang memiliki kemampuan akademik secara profesional dan berakhlak mulia, maka program studi hukum keluarga Islam menerapkan metode pembelajaran yang integratif dan interkonektif pada produk dan praktik keilmuannya. Pada produk keilmuan, mencoba mengintegrasi dan menginterkoneksikan antara ilmu umum dan ilmu agama, sehingga selain menguasai ilmu hukum keluarga, mahasiswa juga menguasai berbagai ilmu agama Islam. Selanjutnya adalah integrasi dan interkoneksi praktik keilmuan antara pengalaman ilmu di lingkungan kampus dan praktik profesi di berbagai instansi hukum. Di antaranya, praktik kuliah lapangan atau PKL di lingkungan kantor urusan agama atau KUA dan praktik peradilan di pengadilan agama dan pengadilan negeri. Mahasiswa program studi hukum keluarga Islam selalu diarahkan untuk memiliki kompetensi akademik yang profesional, berakhlak mulia, memiliki kecakapan sosial, manajerial, dan berjiwa mandiri. Dengan gelar akademik sebagai sarjana hukum, mahasiswa lulusan program studi hukum keluarga Islam sangat berpeluang untuk hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga Yogyakarta. Akhirnya, program studi hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga akan terus berkomitmen untuk mencetak lulusan dengan keahlian profesi, tetapi memiliki basis pengetahuan, sosial, dan spiritual yang matang, sehingga penyerapan alumni tidak hanya bergerak secara spesifik dalam bidang hukum saja, tetapi juga meluas di bidang-bidang lainnya sesuai dengan kebutuhan zaman. Kami berkomitmen untuk itu. Mengabdi untuk kebanggaan negeri. Hukum Keluarga Islam merupakan salah satu program studi Fakultas Syariah dan Hukum Universitas Jakarta dengan peringkat akreditasi A. Program studi hukum keluarga Islam ini sendiri dalam sejarahnya adalah pengembangan dari jurusan Qadha dan Peradilan Agama yang ketika itu masih bersatu sebagai Institut Agama Islam Negeri atau IAIN. Program studi hukum keluarga Islam awalnya bernama Ahwal Syakhsiyah sebelum mendapatkan pengindonesiaan nama pada tahun 2016. Program studi hukum keluarga Islam mempunyai visi untuk menjadi program studi yang unggul dan terkemuka dalam pemaduan dan pengembangan ilmu hukum keluarga Islam atau Ahwal Syakhsiyah bagi peradaban. Untuk merealisasikan visi tersebut, maka misi yang harus dilakukan oleh program studi hukum keluarga Islam adalah sebagai berikut. 1. Mengembangkan pendidikan dan pengajaran dalam bidang ilmu hukum keluarga Islam secara integratif dan interkonektif. 2. Mengembangkan budaya riset dalam bidang ilmu hukum keluarga Islam secara multidisipliner. 3. Meningkatkan peran serta program studi dalam pemberdayaan masyarakat melalui penerapan ilmu hukum keluarga Islam. 4. Mengembangkan jaringan kerjasama program studi hukum keluarga Islam dengan berbagai pihak untuk meningkatkan kualitas pelaksanaan Tridharma perguruan tinggi. Keilmuan antara pengalaman ilmu di lingkungan kampus dan praktek profesi di berbagai instansi hukum. Di antaranya, praktek kuliah lapangan atau PKL di lingkungan kantor urusan agama atau KUA dan praktek peradilan di pengadilan agama dan pengadilan negeri. Mahasiswa program studi hukum keluarga Islam selalu diarahkan untuk memiliki kompetensi akademik yang profesional, berakhlak mulia, memiliki kejerial, dan berjiwa mandiri. Dengan gelar akademik sebagai sarjana hukum, mahasiswa lulusan program studi hukum keluarga Islam sangat berpeluang untuk mengisi berbagai bidang. Di antaranya, hakim pada pengadilan agama dan umum, advokat, konsultan hukum. Akhirnya, program studi hukum keluarga Islam Fakultas Syariah dan Hukum UIN Sunan Kalijaga akan terus berkomitmen untuk mencetak lulusan dengan keahlian profesi, tetapi memiliki basis pengetahuan, sosial, dan spiritual yang matang, sehingga penyerapan alumni tidak hanya bergerak secara spesifik dalam bidang hukum saja, tetapi juga meluas di bidang-bidang lainnya sesuai dengan kebutuhan zaman. Kami berkomitmen untuk itu. Mengabdi untuk kebanggaan negeri. Hukum Keluarga Islam merupakan salah satu program studi Fakultas Syariah dan Hukum Universitas Islam Negeri Sunan Kalijaga Yogyakarta dengan peringkat akreditasi A. Program studi hukum keluarga Islam ini sendiri dalam sejarahnya adalah pengembangan dari jurusan Qadha dan Peradilan Agama yang ketika itu masih bersatu sebagai Institut Agama Islam Negeri atau IAIN. Program studi hukum keluarga Islam awalnya bernama Ahwal Syakhsiyah sebelum mendapatkan pengindonesiaan nama pada tahun 2016. Program studi hukum keluarga Islam mempunyai visi untuk menjadi program studi yang unggul dan terkemuka dalam pemaduan dan pengembangan ilmu hukum keluarga Islam atau Ahwal Syakhsiyah bagi peradaban. Untuk merealisasikan visi tersebut, maka misi yang harus dilakukan oleh program studi hukum keluarga Islam adalah sebagai berikut. 1. Mengembangkan pendidikan dan pengajaran dalam bidang ilmu hukum keluarga Islam secara integratif dan interkonektif. 2. Mengembangkan budaya riset dalam bidang ilmu hukum keluarga Islam secara multidisipliner. 3. Meningkatkan peran serta program studi dalam pemberdayaan masyarakat melalui penerapan ilmu hukum keluarga Islam. 4. Mengembangkan jaringan kerjasama program studi hukum keluarga Islam dengan berbagai pihak untuk meningkatkan kualitas pelaksanaan Tridharma perguruan tinggi. Untuk menghasilkan sarjana ilmu hukum keluarga Islam atau ahwal saksiyah yang memiliki kemampuan akademik secara profesional dan berakhlak mulia, maka program studi hukum keluarga Islam menerapkan metode pembelajaran yang integratif dan interkonektif pada produk dan praktik keilmuannya. Pada produk keilmuan, mencoba mengintegrasi dan menginterkoneksikan antara ilmu umum dan ilmu agama, sehingga selain menguasai ilmu hukum keluarga, mahasiswa juga menguasai berbagai ilmu agama Islam. Selanjutnya adalah integrasi dan interkoneksi praktik keilmuan antara pengalaman ilmu di lingkungan kampus dan praktik profesi di berbagai instansi.
Baik, bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin wa bihi nasta'inu ala umuri dunya waddin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin sayyidina wa maulana Muhammadin. Raditu billahi rabba wa bil islami dina wa bi Muhammadin nabiyya wa rasulah. Subhanaka la ilma lana illa ma 'allamtana innaka antal alimul hakim. Alhamdulillah, ahlan wa sahlan bikudumikum li hadin nadwa al-mubarakah. Sallallahu ayataghammadana bi inayatihi wa taufiqihi amin amin ya rabbal alamin. The 5th Annual International Conference on Law and Sharia, ICOLS, Faculty of Sharia and Law, State Islamic University, Sunan Kalijaga Yogyakarta, Indonesia. نظرا لهذه المادة أو لهذه الحصة من بعض المتكلمين باللغة العربية من دول العرب. إن شاء الله سأتكلم باللغة العربية أحيانا وباللغة الإنجليزية. استئنافا لهذه الأمسية لهذه الندوة هيا بنا نحظو إلى خير ما يفتتح به العمل الصالح وهو تلاوة ما تيسر من الذكر الحكيم بقراءة الفاتحة. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. Good morning, ladies and gentlemen. I would like to say thank you very much for all your coming to this conference. It's my pleasure to welcome all of you here. Well, I'm standing here, me, Sohibul Adkar, as a moderator. It was such a honor leading today's conference. In this conference, we will have 2 seasons. On the first season is speaker. The second for question and answer. And today we have Mrs. Lindra Darnella. Hello, Mrs. Are you there? Okay, maybe we'll join. The second, Dr. Labib Najib. Assalamualaikum ya dokter. Halo. Ayo mewujud walakin mungkin lam yakbal. And the third, Dr. Muwafaq Mas'ud from Zawiya University of Libya. Assalamualaikum. And the last, this is Prof. Dr. Tawad Naipon from Prince of Songkla University, Thailand. Assalamualaikum.
Assalamualaikum.
Waalaikumsalam. Hayakumullah ya dokter. Okay, now we have speaker with a great topic. First speaker will be presented by Dr. Linda Darniala M. from State Islamic University, Sunan Kalijaga Yogyakarta. She has been writing on the title, Do Human Rights Challenge State Sovereignty? Mrs. Lindra. Hello.
Assalamualaikum.
Okay, thank you. Please give applause to Mr. Lindra. And please, Mrs. Linda Darniala M. So without any further ado, the time is yours.
Tibanya. Alhamdulillahirabbil alamin wa sallallahu ala ummati wa ala alihi washabbihi ajma'in. Amma ba'du. Thank you very much for moderator, and also I would like to thank to Ibu Triwahyuni who invited me to be here. And it is really honor for me to be part of the nation. So we can see that self-determination is one of international norm for right for growth. And also we have international criminal codes with Rome Statute when individual as personality in international law. So civil and human rights now become the key factor in the construction of new sovereign states. So this is my title, The Human Rights Challenge Sovereignty, and this is the question. So we start with what is sovereignty. There are some scholars. This is the modern perspective about sovereignty. We can see from Jennings and Watt, and also Wheaton, and also Emmett de Vettel, and also from Standenberg, when they agree that sovereignty is supreme authority and also supreme power. It is different with the definition before from Jane Bodin and also Rashid that claim that sovereignty is the higher authority. Now, now start from Westphalia. Why Westphalia? Because Westphalia is the Westphalia. Westphalia is the international treaty. That's what is the end of the end of the 30 years war, and also in the Westphalia. This is when Westphalia approved that king and person of sovereignty authority. And we see that after Westphalia, we have the scholar very famous. Thomas Hobbes, they put in chapter 13 in his book, Leviathan. They state that the sovereignty recognized is each other. So it is not not only abstract territory and titles. And if human rights are universal rights held equal in inalienability by all individuals, so how could they could be fundamental opposite to the supreme authority of state? So this is the big question. I think that we can. I offer a simple answer that the actual legal and political practice has made human rights and state sovereignty fully compatible. So we can see that if now we have a Universal Declaration of Human Rights, and also we have the International Human Rights Convention, Indonesian already ratified, and several single-issue treaty of declaration established in impressive body of international legal obligation. And this instrument regularly used to language. No one shall be, and everyone has the right. So the international human right obligation of states are solely up to their own national. So this is the state has responsibility when adopt the treaties, have to adopt in national regulation. And this is about the what is the human right. When human rights, individual ground to crime, right, goods, treatment, services, protection, and opportunity of the states. And now we have the UN Commission of Human Rights, who examine human rights situation periodically, for example, when Indonesia want be part of the Human Rights Treaty, has obligation to report annually on their condition on human rights. So and also in practices, we can see that the international society remain larger of social sovereignty of state. So we can see that most of international law is implemented nationally. If we see our constitution, international law scholar in Indonesia already agreed that we have 92% our constitution that's based on international law, especially about human rights. And also we can see that when the spirit of international human rights norm is also what is the collapse of Soviet also because the result of these practices, and also because the international community lack of the authority to stop ever gross and systematic violence. So it is important for international society to international law. So international right norms state largely irrespective of their will. So because they born by customary is in international law. So in international law, treaty not only the source of international law, even international customary law is the first the source of international law resources. And also we have the erga omnes that this is held for all. And also in international law, we have jus cogens. Jus cogens, that means no state can deny the international norms. For example, from the genocide, about genocide and aggression, the crime of aggression, and also the crime of war and crime against humanity. So, next question, is this sovereignty for human rights? Well, what the relevant we talk about sovereignty and human rights, because this is the result is we have the humanitarian intervention. So what is the humanitarian intervention? Humanitarian intervention is protecting from people, other states, from human rights violence. So people, that's mean not only, and also state, not only, but not also state, but also we have the other subject in international law, like international government organization. So there is two ways to humanitarian intervention. One is use of force, and two, humanitarian services. So is it possible to use of force? The question is like we see the last years that happened in Libya and also in Sudan. We have Mofaki here from Libya, and also Palestine and Israel. Is it possible for use of force? And if we see the UN Charter here, it is the UN what is agree with the to respect the sovereignty, because what is yeah, we can see the chapter here, and from the chapter we can see the conclusion is force cannot be used. One, again, the territorial integrity of state. Two, again, the political independence of state, and any other manner inconsistent with the purpose of the UN. So it is prohibited to use of force. But if we see another article in UN Convention here, here you can see, we conclude that force can be used in other states. One, if authorized by Security Council. So humanitarian intervention, it is allowed with held by state or international organization or multilateral humanitarian intervention, but it should do recommendation by from the Security Council, and also in self-defense. And yeah, we already mentioned that we have the Security Council has deal with the issue. And also in this article, we can conclude that respect human rights and the fundamental freedom, have the alternative dispute settlement by peaceful and equal right in self-determination, and joint organization to serve human rights. This is the some recommendation to deal with sovereignty and human rights. And also, now we have the responsibility to protect. Responsibility to protect, that's allow the states by recommendation from Security Council to intervene conflict in the United States. This is my concluding. This is some conclusion here. Sovereignty in international human rights complement each other by strengthening the moral foundation of the state and lending in more credibility in the world community. And also the sovereignty has been modestly transformed rather than undermined or eroded by human rights. And sovereignty that's mean as responsibility and authority. And the end, about ensuring that state keep adequate protection to its population and respect their right, not undermining their authority. So I think in the end, so humanitarian intervention for me is inevitable. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. We'd like to say thank you to Mrs. Dr. Lila Daniela Lamhum for delivering very good presentation. Please everyone give a big applause to our speaker. والآن سنستمع جيدا إلى الكلام عن الإسلام وحقوق الإسلام وحقوق عن الإسلام وحقوق الإنسان. يلقيها أستاذنا العزيز دكتور لبيب نجيب من يمان يونيفرسيتي أو جامعة اليمن، فليتفضل مشكورا.
السلام عليكم ورحمة الله.
وعليكم السلام ورحمة الله.
الصوت واضح؟
أيوة واضح جدا.
طيب. بسم الله الرحمن الرحيم. الحمد لله رب العالمين، والصلاة والسلام الأتمان الأكملان على سيد المرسلين سيدنا محمد وعلى آله وأصحابه الطيبين الطاهرين. أما بعد، فأولا أهنئ إخواني المستمعين وأهنئ الأمة الإسلامية بميلاد سيد الورى صلى الله عليه وسلم، ونحن في شهر ربيع الأنوار. وثانيا أشكركم على إقامة مثل هذه الندوات النافعة المباركة التي تكثر حاجة الناس إليها. وأبتدئ موضوعي حول الإسلام وحقوق الإنسان. الله سبحانه وتعالى كرم الإنسان وفضله على كثير ممن خلق تفضيلا، فقال سبحانه وتعالى في سورة الإسراء: ولقد كرمنا بني آدم وحملناهم في البر والبحر ورزقناهم من الطيبات وفضلناهم على كثير ممن خلقنا تفضيلا. فجمعت هذه الآية الكريمة 5 منن أنعم الله سبحانه وتعالى بها على الإنسان: نعمة التكريم، ونعمة تسخير مراكب البر، ونعمة تسخير مراكب البحر، والرزق الطيب، والتفضيل على كثير من المخلوقات. والله سبحانه وتعالى جعل من مقاصد بعثة الرسل عليهم الصلاة والسلام رفع الظلم عن المستضعفين وانتزاع حقوقهم من الظالمين. فقال سبحانه وتعالى في كتابه الكريم: ونريد أن نمن على الذين استضعفوا في الأرض ونجعلهم أئمة ونجعلهم الوارثين ونمكن لهم في الأرض. إن تاريخ حقوق الإنسان تاريخ قديم في الشريعة الإسلامية، بل إن الشريعة الإسلامية جاءت لتعطي الإنسان حقه الذي ينبغي أن يكون له. فما يظنه بعضهم أن حقوق الإنسان إنما جاءت عقب الثورة الفرنسية التي قامت في عام 1789، وأن هذه الثورة هي التي قررت حقوق الإنسان. هذا خطأ واضح. فالشرائع السماوية هي التي قررت حقوق الإنسان، والإسلام رفع من شأن هذه الحقوق، فلم يجعلها حقوقا مجردة، بل جعلها ضرورات لا بد للإنسان منها، كحق الإنسان في الأمن، وحق الإنسان في الحرية، وحق الإنسان في التعليم، وحق الإنسان في الصحة، وحق الإنسان في المسكن. ومن كان يحول بين الإنسان وهذه الحقوق فهو معتد يلحقه الإثم الشديد، ويجب إبعاده عن الحيلولة بين الإنسان وحقوقه. وهذه الضروريات التي هي حقوق للإنسان إذا اختلت اختل ميزان التشريع. ولذلك إذا حصل الخوف للإنسان ترتبت أحكام تليق بذلك الخوف. وإذا سلب الإنسان حريته التي هي أغلى ما يملك فإنه حينئذ يعيش بهيميا، أي كالبهيمة، يأكل ويشرب لكنه عاجز أن يعبر عما بداخله وأن يصرح بما في مكنونه، فهو وإن كان آدمي الصورة إلا أنه بهيمي الحياة، لأنه فقد أغلى ما يملك وهو حقه في التعبير. فالإسلام جاء ليقرر للإنسان أن له حرية التعبير، وأن له أن يتمتع بالحقوق التي تليق بمكانته كإنسان من حرية وأمن ومطعم وصحة وغير ذلك. ولذلك دين الإسلام جاء من خلال تشريعاته ووجد مشكلة متفاقمة في بلاد العرب، وهي مشكلة العبيد والرقيق. فقام الإسلام من خلال التشريعات إلى تحجيم هذا الرق وتقليصه، ورغب ملاك العبيد بالعتق مجانا تقربا إلى الله سبحانه وتعالى، ورتب على ذلك الثواب العظيم. وأيضا جعل العتق إحدى الخصال في الكفارات، سواء في كفارة اليمين أو في كفارات بالصيام أو في كفارات الظهار أو في كفارات القتل، ليكسب الإنسان بذلك حريته في ظل التشريعات الإسلامية. بل وجعل الإسلام نصيبا في الزكاة الواجبة للأرقاء الذين يطلبون الحرية ويكاتبون ساداتهم أن يدفعوا لهم أموالا من أجل أن ينالوا حريتهم، أن يعانوا من مال الزكاة حتى ترد إليهم حريتهم. والإسلام أغلق جميع مصادر الرق إلا الحرب المشروعة مع الكفار، فجاء الاسترقاق خيارا غير متعين من خيارات أخرى متعددة. هذا يدل على اهتمام الإسلام بحرية الإنسان، وأنه لا يشجع أن يكون الإنسان عبدا رقيقا تحت سيد يأمره وينهاه. وألغى الإسلام الربا الذي كان من خلاله يتسلط الأثرياء على الفقراء ويستغلون حاجاتهم، فيعيش الفقراء خاضعين لهؤلاء الأثرياء الجشعين الذين يستغلون حاجة الناس. وجعل الإسلام في مصارف الزكاة سهما لأولئك الغارمين الذين أعجزتهم الديون حتى تقضى ديونهم، ويبقى الإنسان مرفوع الرأس حرا يتمتع بكامل حقوقه ليس أسيرا لدائنيه. والإسلام كفل حرية المعتقد للإنسان، كفل الإسلام حرية المعتقد للإنسان، فالإسلام لا يكره الشعوب ولا الأفراد على اعتناقه. قال الله سبحانه وتعالى في كتابه الكريم: لا إكراه في الدين قد تبين الرشد من الغي. فنفى الله سبحانه وتعالى أن يكون في الدين إكراه. وقال سبحانه وتعالى في سورة الكهف: فمن شاء فليؤمن ومن شاء فليكفر. إن هذه الآيات تجسد حرية المعتقد التي يتمتع بها الإنسان. دعا الإسلام الإنسان إلى التفكر في الكون وآياته حتى يصل إلى العقيدة الصحيحة التي فطر عليها دون إملاء أو إرغام من أحد. فقال سبحانه وتعالى: قل انظروا ماذا في السماوات والأرض. وقال عز وجل: أولم يتفكروا في أنفسهم ما خلق الله السماوات والأرض وما بينهما إلا بالحق وأجل مسمى وإن كثيرا من الناس بلقاء ربهم لكافرون. أيها المستمعون الأفاضل، إن التفكر والتدبر وإن النظر والاعتبار هي المسالك التي كفلها الإسلام للإنسان ليصل إلى النتائج التي سيتحمل عواقبها في مستقبل حياته. إن الإسلام كفل للإنسان حرية التعبير في أموره السياسية فيما يتعلق بسياسة الدولة، فكفل الإسلام للإنسان حق الشورى التي هي الأسلوب المرتضى بالشريعة الإسلامية ليكون أسلوب حكم. فالشورى فريضة شرعية واجبة ليس حقا مجردا للإنسان، بل الله سبحانه وتعالى افترض أن يكون منهج الحكم بين الناس هو منهج الشورى. فقال سبحانه وتعالى واصفا عباده المؤمنين: وأمرهم شورى بينهم. وقال سبحانه وتعالى لنبيه صلى الله عليه وسلم: فإذا عزمت، قال سبحانه وتعالى: فاعف عنهم واستغفر لهم وشاورهم في الأمر فإذا عزمت فتوكل على الله. فأمره سبحانه وتعالى أن يشاور في الأمر، ولم يكن أحد أكثر من النبي صلى الله عليه وسلم مشاورة لأصحابه، فإن النبي صلى الله عليه وسلم مارس مبدأ الشورى فعليا كما في غزواته. فعندما كانت غزوة بدر اختار صلى الله عليه وسلم مكانا لنزول الجيش، ثم شاور أصحابه فأشار عليه بعض أصحابه بتغيير ذلك المكان. وفي شأن الأسارى يوم بدر استشار النبي صلى الله عليه وسلم أصحابه فيهم أيقتلهم أم يمن عليهم بالفداء، فأشار أبو بكر الصديق رضي الله تعالى عنه إلى أن يفادي بهم، أن يمن عليهم فيطلق سراحهم، وأشار عمر بن الخطاب إلى قتلهم. واستشار النبي صلى الله عليه وسلم أصحابه في شأن إعطاء الأحزاب ثلث الثمار من المدينة في يوم الأحزاب. فالنبي عليه الصلاة والسلام جسد مبدأ الشورى تجسيدا عمليا واقعيا لا مجرد تنظيرا. ولذلك بارك الله فيكم إن هذا المبدأ حق من حقوق الإنسان وفريضة من فرائض الشرع أن يمارس الإنسان مبدأ الشورى في حياته وفي الدولة التي يقيم فيها. ولذا قال أهل العلم إن الحاكم الذي لا يستشير أهل العلم والدين والاختصاص عزله واجب. إن مبدأ الشورى مبدأ عرفه الحكام ليس من حكام المسلمين فقط بل حتى من قبل الإسلام. فهذا القرآن الكريم يصف بلقيس ملكة سبأ أنها قالت لقومها ما كنت قاطعة أمرا حتى تشهدون. وهذا فرعون الذي رفض دعوة موسى عليه الصلاة والسلام عندما جاءه وعرض عليه المعجزات. قال فرعون إن هذا لساحر عليم، يقصد موسى عليه الصلاة والسلام، يريد أن يخرجكم من أرضكم فماذا تأمرون؟ يستشير الملأ، يستشير الوزراء والأعوان والحاشية. قالوا أرجه أخاه وأرسل في المدائن حاشرين يأتوك بكل ساحر عليم. إن مبدأ الشورى حق إنساني، واليوم نجد في دول العالم الثالث سواء في العالم العربي أو في غيره من يمارس القهر والاستبداد ويضرب بالشورى عرض الحائط مصادرة لحق من حقوق الناس وهو حق الشورى. إذن لا حرية في المواقف السياسية ولا حق في الأمن ولا حق في حرية معتقد ولا توجد الحقوق التي جاء بها الإسلام لهذا الإنسان تكريما ورفعة لشأنه. إننا في القرن 21 الميلادي والعدل لا زال غائبا في كثير من دول العالم. هذا العدل الذي تطالب به الشعوب فيخرجون مظاهرات ينادون يصرخون يصيحون يطالبون بالعدل، لكن العدل هذا الذي هو حق لهم ما زال غائبا عنهم. الله سبحانه وتعالى أمر بإقامته على سبيل العموم، فقال سبحانه وتعالى في كتابه الكريم إن الله يأمر بالعدل والإحسان وإيتاء ذي القربى وينهى عن الفحشاء والمنكر والبغي يعظكم لعلكم تذكرون. وأمر الله سبحانه وتعالى بالعدل خصوصا في الحكم فقال إن الله يأمركم أن تؤدوا الأمانات إلى أهلها وإذا حكمتم بين الناس أن تحكموا بالعدل إن الله نعم ما يعظكم به إن الله كان سميعا بصيرا. أيها الفضلاء، إن هذا العدل الذي هو حق للإنسان كفله الإسلام وكفله العقل وكفلته الفطرة الصحيحة، وحذر الإسلام من ضده وهو الظلم الذي حرمه الله سبحانه وتعالى على نفسه وجعله محرما بين عباده، فقال في الحديث القدسي يا عبادي إني حرمت الظلم على نفسي وجعلته بينكم يقتصر الإسلام على التحذير من الظلم والتحذير من الظالمين وبيان عقوبتهم في الدنيا وفي الآخرة. لم يقتصر الأمر على ذلك، بل حذر الإسلام من الركون إلى الظالمين ومعاونتهم والوقوف معهم وشد أزرهم، فقال سبحانه وتعالى في كتابه الكريم ولا تركنوا إلى الذين ظلموا فتمسكم النار وما لكم من دون الله من أولياء ثم لا تنصرون. وجعل الإسلام أفضل الجهاد أن يقول رجل كلمة حق عند سلطان جائر. أيها الفضلاء، إن من الحقوق التي جاء بها الإسلام حق التعليم لكل إنسان أن يتعلم ما هو نافع له في حياته، ما يجعل حياته حياة سلسة يسيرة. هذا الحق، حق التعليم، نطق به القرآن الكريم. فأول كلمة نزلت على النبي صلى الله عليه وسلم في هذا الوحي هي قول الله سبحانه وتعالى: بسم الله الرحمن الرحيم، اقرأ باسم ربك الذي خلق، خلق الإنسان من علق، اقرأ وربك الأكرم الذي علم بالقلم، علم الإنسان ما لم يعلم. فالله سبحانه وتعالى كفل حق التعليم لكل إنسان. وأقسم الله سبحانه وتعالى بالقلم الذي هو وسيلة الكتابة فقال: بسم الله الرحمن الرحيم، نون والقلم وما يسطرون. وقال النبي عليه الصلاة والسلام: طلب العلم فريضة على كل مسلم. عظم الإسلام شأن العلماء ونفى أن يساوى العلماء بغيرهم من الجهال، ورتب الثواب الجزيل على لمن يطلب العلم، وجعل العلم طريقا إلى الجنة، وجعله ميراثا للأنبياء والرسل عليهم الصلاة والسلام. إذا تقرر هذا فالإسلام قد كفل حق الإنسان في التعلم، وكفل حق الإنسان في الصحة، وكفل حق الإنسان في الأمن، وكفل حق الإنسان في المشاركة السياسية، وكفل حق الإنسان في حرية الاعتقاد، وكفل حق الإنسان في كثير من جوانب الحياة. هذه الحقوق صارت مسلوبة في حياتنا اليوم، لا نكاد نراها إلا في كتب وندوات، أما في الواقع فإنها لا نكاد نشاهد منها إلا ما يدمع العين ويحزن القلب. أكتفي بهذه المشاركة لأن زمني قد انتهى، والله أعلم. وتحياتي لكم جميعا من المشاركين ومن المستمعين، والله أعلم. وصل اللهم وسلم وبارك على سيدنا محمد وآله وصحبه أجمعين، والسلام عليكم ورحمة الله تعالى وبركاته.
وعليكم السلام ورحمة الله وبركاته. إن شاء الله. شكرا على هذا الكلام الجميل يعني عن الإسلام وحقوق الإسلام وحقوق الإنسان. يعني قد سمعنا بتمام يعني 20 دقيقة. جزاك الله يا خير. Alhamdulillah. Welcome to the next presentation. We'll have a brief presentation on having an honor to invite Dr. Muwafaq Mas'ud. Assalamualaikum ya Doktor.
Waalaikumsalam warahmatullahi wabarakatuh.
سيكون اللقاء باللغة العربية والإنجليزية أو إنجليزية يا دكتور؟
Bisa dua-duanya, bisa bertiga, bahasa Indonesia juga. The PowerPoint file, is it already on the screen? Or screen sharing?
لسه ما جاش يا
You
دكتور.
still need to click it. Click it.
Twice click.
We saw your two files, but you still need to click one of them.
One of them. I go for the PDF. So my title is about the ruling by other than what Allah has revealed. In Arabic, it's about الحكم بغير ما أنزل الله. تطور الفكر الإسلامي الحديث وعلاقته.
ممكن ترسل يعني الملف حتى نضيف في الشاشة هنا.
حسنا.
أيوة طيب ننتظر.
You got it or not? Oh, okay, in the same thing.
Okay, I already has your paper. After this, I will show to the screen, so you can continue your speech.
Is it already there or not?
Yeah, I already. After this, I will show the screen. Mr. Dr. Muwafaq, mungkin نلقي مباشرة يعني.
So the topic is about the الحكم بغير ما أنزل الله, or ruling by other than what Allah has revealed. From actually most of our problems today as Muslims related to this topic. When we talk about law, we talk about Sharia, Islamic law or Islamic Sharia. That is the issue which is very important for Muslims and non-Muslims at the same time. Here we have, when we talk about this, we have like in Sunan Kalijaga, the name of the faculty, it's the faculty of Sharia and law. In Arabic, it's written there, just Kulliyat Sharia. In many other Arab, change the name to like Faculty of Sharia. Then after a while, they change it again to the Faculty of Law. Again, Faculty of Sharia and Law. Here we have to know the difference between law and Sharia. Law, it's made by people. Rules by, for the next slide, one related came from Allah subhanahu wa ta'ala. Human made the law, we can change the law, and for the Sharia, we cannot change it. It's fixed there in the Quran al-Kareem. So in the second slide here, we have law is human-made, Sharia is transcendental, and law is changeable, Sharia is permanent. Then we go to the legal system in our time. Legal system in the Arab countries and most Islamic countries, we have two systems at the same time. One of them is classical, traditional, like Islamic way. In the classical one, we call it Qadi Shar'i right now, a judge who renders decisions according to Sharia or according to Ahkam al-Quran wa Sunnah. The other one, the modern Qadi now, just according to rules, decisions according to law, according to the constitution. not the Sharia, not necessary to the Sharia. The classical system is independent, where the judge can make his own decision without referring back to any constitution or just referring to Al-Quran and Qadi. He referred to the law according to item number 4, year 2000, using fiqh from Hanbali, the madhab which you refer as a judge refers to. So sometimes you have this this crime. According to Imam Malik, it's not a crime. According to Abi Hanifa, it's a crime. So the classical traditional way can be can work as a qadi, males. In modern system, you have males and females. You have judges working, female judges studying in Sharia and law. So in modern way, in modern system, it's accepted, while in traditional system, it's not accepted. Then I go to the first slide where we have a change from Sharia to law. So the Sharia, it comes from Allah. The law, human made. When we live now during the time of globalization, we have this kind of fixed, this kind of change. Just we have the traditional way of having khilafah. So now we have a modern state. It's completely different from khilafah system. This is the impact of globalization. After the fall of Ottoman Empire, we don't have khilafah and one khalifa. Now we have modern states with certain borders, certain people, and with their own political system. So this is the impact of globalization. And we have the educational system. The educational system, it's Zawaya. So that's a place used to teach Quran and Sunnah. In Indonesia, you have pesantren. In many other countries, they have their own system. While in modern educational system, you have to follow primary school, secondary school, university, BA, master degree, PhD. So the male, when we talk about gender equality, these are as a result of globalization. And then we have one of the most important parts of globalization, the economy. Now we have Islamic banking, Islamic economy, stuff like this, because we want to live in this globalized world. Then these are just some examples of the impact of globalization, about stoning, hand cutting, hudud in Islam, حد الرجم, حد السرقة, and we have slaves and mulk al-yamin. It's related to globalization. You cannot have slaves right now. You cannot have people who you can sell, and you cannot travel from one place to another without passport. You cannot carry, for example, mulk al-yamin with you. We have freedom of belief. It's very modern time. Even when we talk about the freedom in Islam, you can join Islam, but you cannot go out of Islam. You can believe in Islam. You are free, but you are not free to leave it, even after a day. This is one of the impacts of globalization. You can convert people to Islam, but it's not for them. They feel they are free to leave. But for in Islam, you cannot globalization. You cannot have jihad because it's you are attacking another country, even if it's not Islamic country. It's not accepted during the time of globalization. Gender equality, this is one of the very critical issues, even I don't like to talk about, because it's people, they talked about this topic mostly more than any other topic, very near each other. It's like a small village. We have science and the impact of science on religion. Our understanding of religion according to science increase rate. This is the first time in human history, most than 50%. Leave the traditional books, and before they cannot read and write, just they follow what scholars ask. Now they can read, they can write. And we have the critical thinking. They can criticize people now. It's not like before. They accept the Sharia or the law or the hudud without thinking. Now they are start asking questions. Why? Why if I do this, I get that? Some examples of traditional mostly أنزل الله ضد الحكم بغير ما أنزل الله, or the concept of توحيد الحاكمية. توحيد الحاكمية, it's the الحكم إن الحكم إلا لله. Allah, the only one who gave hudud, not human beings. So in 10 nullifiers of Islam, نواقض الإسلام العشرة, Sheikh Muhammad bin Abdul Wahab, the fourth one and the ninth one related to the use of law, the use of something against God's about Tawheed al-Hakimiyya. So he gives examples of this scattered mostly in all his books. He always talking about this kind of Tawheed, that al-hukmu lillah, not to human beings. And Sheikh Muhammad Nasir Din al-Albani is also supporting what Sayyid Qutb and Abil A'la al-Mawdudi, what they said about Tawheed al-Hakimiyya. So he accepted as people to think about this. Then we have some other scholars who discussed this. We have Ahmed Muhammad Shakir, and we have modern some Sheikh Yusuf al-Qaradawi, and we have Sheikh Muhammad al-Amin al-Shanqiti. So they are talking about this tawheed, this kind of, you have to follow what Allah subhanahu wa ta'ala has revealed, not what we as humans, we produce, we write, because it's just a law. And then finally, the impact of ruling by other than what Allah has revealed on our life today. We have many groups, Islamic groups, who talks about the Sharia and the law, and uses Sharia and law to fight one of the most modern states which tried to manipulate Sharia in its system. Until now, it's because of the impact of globalization, they cannot manipulate Sharia law according to their understanding or according to the traditional understanding in their government, because we are not living alone in a closed country. We have the most offensive example, the Islamic State. They applied it, they refused whatever law we have right now, and for them, they applied their own understanding of Sharia law, not the modern law. And the impact of this, we just all saw it on Syria, on Iraq, many other Arab countries. They suffered because of this. And finally, we have the most moderate ones. They are the Islamic parties, Muslim Brotherhood, they practice politics. So we see the reaction of people against these Islamic parties. Even when they talk about Sharia, we have, in fact, even the people, they are divided. Some of them with applying Sharia, others against applying Sharia. And this, even all of them, they are Muslims, but they have this kind of division. People, they fear Sharia, they have their own understanding, they don't applying Sharia and becoming more offensive than even the regular regimes. So the question, finally, is it possible to apply the Sharia 100% in our modern time, or we need to apply Sharia and law? In أحوال الشخصية we can apply Sharia, but in معاملات, is it possible to have economy? Even now, when we talk about Islamic economy, it's not 100% Islamic. We have the concept of riba still there. So why we change the names just to call it this bank is Islamic following the Sharia? Like in Indonesia, I find mostly BNI Sharia, Mandiri Sharia. So what's the difference between both of them? Both of them, they have the same roots. So can we have both of them, or just we have one, or one which is modern one? But can we have this is one issue in Libya now. We cannot have the traditional one because the traditional fiqh based on gold and silver, not on paper money. So when we talk about Sharia, is it possible or not? That's the question. Thank you very much for listening, and terima kasih.
Okay. We'd like to say thank you to Mr. Dr. Muhammad Masoud for delivering a very good presentation. Please everyone give a big applause to our speaker. Thank you, sir. And the next, welcome our next presentation. We have a presentation now, and I'm having an honor to invite Mr. Assistant Professor Dr. Tawat Naipon from Prince of Songla University, Thailand. Hello, Assalamualaikum. Okay.
Waalaikumsalam warahmatullahi wabarakatuh.
Okay. Without any further ado, the time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. First of all, I would like to thank the organizing committee who has invited me to speak in this conference. Alhamdulillah. And also, internet is a Sawadee Cup, yeah. And so we in our area, we use the Malay language, which is our Kelantanese dialect, yeah. So, inshallah, today I am going to discuss with you about the applications of Islamic law in Thailand. This I've been focused on the case of Islamic financial institutions in the country. So, what are the subtopics? First of all, I would like to give you brief introductions on Thailand and Muslim in Thailand. At least some of you might not have basic information about Muslim in the country. And when we look at what are the Islamic law available, enforceable in Thailand. And then the third, I'm going in more details on the application of Islamic law in Islamic financial institution. will follow by the conclusions and recommendations, inshallah. So, in Thailand, according to government statistics in 2010, it is said that Muslims, the number of Muslims is 3.2 million out of 66 million population, the total population of Thailand, which is about 4.6%. And of course, among the Muslims, we know that we are at least, 6 million Muslims in Thailand. So of course, here we follow the government or the officials numbers, yeah. And most of the Muslims are living across Thailand. In Thailand, we have 76 provinces. So across all the provinces, you will find Muslims, you will find mosques in those provinces. But majority of them are living in 4 southern provinces of Thailand. I'm sure you have heard about Pattani, Yala, Narathiwat, and Satun. And this area, people speak Malay as of their mother tongue. Across Thailand, we have about almost 4,000 mosques. Yeah, if you have been to Bangkok, you will say that it's difficult to find mosques and Muslim restaurants, for example, in Bangkok. But in Bangkok itself, you can find 183 mosques, based on the statistics of the Muslim in Thailand 2018. Out of 76 provinces, 36 provinces that we have Islamic provincial Islamic Council. Yeah, only 36, because any province that has mosques of more than 3 mosques, then they are entitled or they can apply to have also Islamic councils. Yeah. So if you come to Pattani, our area, 185 Islamic schools or madrasa. So you'll see a lot of people speak Arabic in our area and also, of course, speak Malay. So Thailand, of course, is an agricultural base, and we are, the Muslims areas, is the poorest areas of the country, especially Narathiwat and Pattani. We are often among the 5 poorest provinces in Thailand. And since 2004, we have a lot of violence in this area that causing almost like 7,000 deaths and a lot of injuries. And during this pandemic of COVID-19, Pattani and Yala are among the top 3 provinces in Thailand with highest reported cases. Like for today alone, in Pattani, we have over 500 cases. And the number of population of Pattani is only 700,000 people. That's all about, the introductions. Yeah? So when we talk about the 4 provinces, we are talking about this area. Yeah, very border to Malaysia. Yeah, only 4 provinces here. So Bangkok is here. So now, what are the laws that are available in Thailand? Yeah, Islamic law that we have in Thailand, the official framework, we have the Administration of Muslim Organization Act, 1997. This is the main law. It's not exactly like Sharia law, but the main law concerning Muslim in Thailand. And this law allowed the Central Islamic Council of Thailand to issue some rules and regulations on Muslims matters. Anything they can issue something on zakah, something on halal, not halal. They can issue the rules and regulations, but not the law. So next, the Thailand law that has been issued according to the codes of Muslim family law and law of inheritance. That was issued or enacted in 1941. But this law is applicable only for Muslim majority provinces that I have told you earlier. So with this law, so we call Tok Kodi. Yeah, each province you have 2 Tok Kodi to give advice to the Thai civil judges on family and inheritance cases involving Muslims in the provincial court. Yeah, but they don't deliver any final judgment. And recently, in Muslim areas, the government are trying to use the alternative dispute resolutions, or we call ADR, using Islamic principles as well. These are the law that have been assessed in Thailand. So now I turn my focus into the application of Islamic law in Islamic financial institutions. So in Thailand, the financial institutions, we have one Islamic bank, we call iBank, that under the supervision of Bank of Thailand. This is the only one bank, Islamic banks. And we have also the insurance companies, we call takaful companies. Yeah, and we have the 2 asset management companies. Yeah, Islamic asset management. And we have another one we call Islamic corporate. Islamic, yeah. So in general, Islamic Bank was established based on Islamic Bank Act 2002. And the bank has the Sharia supervisory boards. It's the same with other types of Islamic financial institutions. But Islamic management, asset management, takaful companies, and Islamic cooperatives, there is no specific Islamic law enforceable. So we follow the Thailand law. Yeah, but in terms of practice, to ensure the Sharia compliance, we have the Sharia Supervisory Committee or Sharia Supervisory Board for each of these organizations. So if we look in specifically in 2 main Islamic financial institutions in Thailand, is iBank and Islamic cooperatives. Yeah. Some might ask, how big is the biggest Islamic cooperatives? The biggest one has the asset of over 4,000 million baht. In Thailand, according to the law, if you have 5,000 million baht, you can establish a bank. Yeah, so it's quite big, quite huge. So the legal framework, of course, Islamic Bank of Thailand, there is a law, the Act provides. But Islamic cooperatives, we follow the Cooperative Act 1999, and also we follow the civil law, civil and commercial codes of Thailand. In terms of financial products and services, Islamic Bank, they adopted all the financial services and products from Islamic Bank of Malaysia. So that means they use a lot of old principles. You can find all the products available in iBank or Islamic Bank of Thailand, also available in other Islamic bank. As for the Islamic cooperatives, there are few products. They have only musharaka, very basic principle, and we have takaful also. And recently they have ar-rahman for the members of the cooperatives. In terms of Sharia Supervisory Board, I think that there are the 4 members Supervisory Board, Sharia Supervisory Board, and they have regular meeting. but they are quite reactive. What I mean by reactive is they cannot go and check into the systems to do Sharia audit to ask for some issues. What they do, they wait and until the management of the Islamic Bank requested them to give certain fatwa or certain activities, then they will do it. But they do have regular meetings. Among the board members, actually the Islamic cooperatives do have three in line or in compliant with Islamic law. Surprisingly, in iBank, Islamic Bank, they don't have a system in place. The Sharia audit, they don't have that. In Islamic cooperative also the same. They don't have the Sharia audit. So what are the problems that you might find that they are using Mudaraba in buying and selling of goods, but they are certainly using the country legal framework. Yeah, they use Islamic law. Yeah, Mudaraba, for example, but they use the commercial code in terms of permutations. And for example, if they want to sue someone, this either taken from Islamic bank in other countries, especially Malaysia, or using own contracts, Islamic financial institutions. So they don't go for innovations, they go for very simple to manage Islamic financial products. The third, there is no national Sharia supervisory boards in Thailand. So when the Islamic financial institutions, Sharia people, so you may find in terms of practice, there are a lot of differences between the fatwa made by one Islamic cooperative to the other. The fourth one, the role of Sharia supervisory board are very limited, and they often act based on the requests of the management of the Islamic cooperatives and as Islamic bank, of course. So they don't have any proactive activities have been done by the Sharia supervisory board or committees. So and also there is a question of independency of this board. I mean, whatever they do, the management, and most of the time they somehow follow the will of the management of the Islamic financial institutions. So there's no proper Sharia audit systems in place. That a lot of issues on Sharia non-compliance in practice. So my recommendation is, the National Sharia Board for Islamic financial institutions should be established. This could be established by the Islamic the full Sharia court could be established in Thailand. So that all the cases related to Muslim family and inheritance, and also the cases from the financial institution. This is to ensure the Islamicity of Islamic financial institutions. Otherwise, the questions, are Islamic financial institutions Islamic? Will be the big questions that people will ask in Thailand and beyond. With that, I would like to thank again the organizing committee and Assalamualaikum warahmatullahi wabarakatuh. ขอบคุณครับ
Waalaikumsalam warahmatullahi wabarakatuh. We'd like to say thank you to Mr. Professor Dr. Tawad Naipon for delivering a good presentation. Please everyone give a big applause to our speaker. Ladies and gentlemen, now we come to the question and answer session. Visit all presentations given as well as we heard before. First, raise your hand, spell your name, and what faculty of to whom this question you asked, and we'll invite to you raise your hand. Any question, maybe? تفضلوا من الحاضرين ممكن واحدا منكم أو ممكن اثنين أو ثلاث سيسأل المتكلمين ممكن إذا يكون باللغة العربية إلى خصوصا إلى الدكتور لبيب. Is there any question?
Invite someone else. Thank you very much. I would like to thank the all presenters for the presentations, to Dr. Motok and Dr. Michael. I'm sorry. Yeah, my interest is in family law, but I would like to ask you a question about the product of Sharia economy, or more conventional economy. So it seems that you are wondering if Islamic banking or Islamic economy is Islamic. So I would like to ask you a question, and maybe this could be also answered by Dr. Naiful. If I'm not mistaken, there is of course difference between Islamic economy and conventional economy. This is what is always, of course, propagated by the the speakers of Muslim who propose Islamic economy atau Sharia economy. It's quite difficult for me to say this Islamic economy. So I would like to provide one example of the difference between these two systems. Let me give an example of, like, for example, house buying by a Muslim. I, for example, wanted to buy a house, and to the conventional banks, when I wanted to have collect loan from the conventional bank, and the conventional bank would give me a loan of, like, for example, 500 millions, because the price of the house is 500 million rupiah. And after that, I have to return the amount of money of 400 million rupiah to the bank with the bunga, with the what is bunga? With the rent? Yes. Yeah. I forgot. So sorry about the word that I have to choose. For example, I have to return like 750 million. So I have to, like, return 250 million more, or 350 million more. And when I come to the Islamic banking, the Islamic banking would do in different way. They would say to me, okay, I would give you like a loan, but this is not in the loan transaction. This is in as 750, 100 millions, just the same as the amount of money that I have to return to the conventional. I don't know if I still would go to Islamic banking because, yeah, maybe it would depend on my ideology, on my keyakinan, yeah, religious faith. Okay, because I'm Muslim, I would go to Islamic banking. But if, for example, when I go to the Islamic banking, then the Islamic banking asks me to pay more than 750 million, let's say like 800 million, I think, although I'm Muslim, I might go to conventional bank. So, I mean, there is difference actually. The difference is in the contract. But the substance of the Islamic banking is, of course, the welfare of Muslim. So, welfare of Muslim. I mean, I just wanted to have the reaction to mention. I think that this is what happened. Are interested in propagating Islamic banking, said that it could not be happening because we always try to observe the practice of the Islamic, or conventional bank. So we always want to have like the decision or the policy that would make Muslim in prosperous situation economically. So maybe I just wanted to, ask you to have, you to give me like feedback or reaction from your side and from also from I will call it from Thailand. Thank you very much. Maybe this is a bit complicated, but this is what I wanted to ask you and to have your comment on my issue. Thank you.
Okay, thank you to Prof. His for the question. Actually, it is very clear about the case and about the question. I think we will hear immediately to Dr. Muafak Masoud and after that to Dr. Tawad Naipon. Okay, the first to
Thank you very much for the
Dr. Muafak. The time is yours.
Yeah, thank you very much. Thank you very much for the question. Actually, from when we look at this transaction in Islamic banking, from now I will look at it from traditional way, traditional fiqh. From according to traditional fiqh, we are going from the back door to riba because the bank does not want to buy the house for itself. They want to buy it for you. So this is the riba, and we are going around the riba to make it halal. So this is the traditional view of this transaction. If the bank buys the house for itself and then resell it again with a certain price, then this is jual bili. This is a regular transaction. But because you want this house, the bank goes to this house, not to another house. So in this case, the Islamic banking or the Islamic economy or whatever, they are still have the concept of interest because actually they want to have profit. They are not a charity organization. They must get money to continue their job. So the transaction itself, it's not halal 100%. But for us as emotional Muslims, we want this transaction because this is selling and buying. But in fact, it's not like this. Actually, in some countries, they give another option to give you the money which you want, but in gold.
not paper money. What happened next? You return them in gold again. So if you want to buy with 500 juta a house, they give you a loan. They buy gold with 500 juta, and they give you this gold to resell it again. And for you, you return to them not money. You return to them gold in 2, 3, 4 years, like 10 grams gold per month, until you reach the same amount which they gave it to you. But this is impossible. Paper money, they have one of its characteristics, its value. You can buy a house with 10 millions before 20 years. Now you cannot even buy anything with this amount. So the money, they loses its value, so they have to put this interest. That's why people, they prefer to go to gold instead of paper money. If they give you gold right now, the value of gold will increase over time. And this is what their profit, because the value of the gold which they give you now will increase over time. This is their profit exactly. But this is impossible. So that's why many scholars, they see Islamic banking and Islamic economy as a backdoor to get even more interest sometimes, more than the traditional bank. Sometimes you go just to the traditional bank and it's cheaper than the Islamic bank. Yeah, thank you very much.
Thank you. Thank you.
Okay. The next to Assistant Professor Dr. Tawad Naipong to answer the same question from Prof. Ais Nurlailawati.
Okay. Bismillahirrahmanirrahim. I do agree with Sister Nurlailawati, yeah? And I have been asked several times about this in Thailand, because it's just the same, you know. If, for example, if you buy the house, yeah, from Islam, like, okay, let look at my case. I buy a house from Islamic cooperatives, so it's they get the profit rate, yeah, of 6%. But if I buy the house from the conventional banks, they will charge me only 2.5% interest rate. That's what happened in Thailand. So when we look at this case, you know, I would like to make 3 important points. This case is much more, okay, apart from the Sharia point of view that our brother has already mentioned, it's much more about the management, about the marketing, about the efficiency and effectiveness of Islamic bank and cooperatives. So whatever is not mentioned, so it can be done. Yeah, that's this muamalat. The first thing that you have to understand. And so in the case here, the problem is not just only interest not allowed. But another one is exploitations. Okay, exploitations. Is the case of, you know, profit rate of 6% is an exploitations. That's the question mark. Why? You know, when we talk about the exploitations, most of the times we compare it between the market, yeah, average market interest rate, for example, with the, you know, the Islamic bank profit rate, for example. If very big gap there, to me, I feel there is an exploitation happen. Capital, you know, but not in Islamic bank and Islamic cooperative. That surprised me a lot. That's the problem with the, you know, management of the Islamic financial institutions. You know, so you chase people away, you know, because people expect that you even to be effective and of course cheaper, impossible, because Islamic bank, of course, is a business plus, you know, welfare also. at least certain part of Sharia will ensure the welfare of the people and society. And you know, in the real world, they are talking about CSR. We can do it actually, but we have to be effective and efficient in our management. So to me, okay, in the first, if you are maybe the first few years, yeah, like in Thailand, in some companies only 1 year, 2 years, you know, it could be acceptable to me because there are a lot of costs, yeah, cost of the capital, maybe involve cost of the staff and something cost of setting up the Islamic cooperative. So your profit rate might be higher than the conventional bank. But for those Islamic financial institutions with experience, 10 years, 20 years, your rate should be competitive with the conventional banks. Otherwise, you cannot expect us to be welfare if the bank is not a welfare. You don't care about the benefit of the Muslim Ummah. You know, so you use Sharia, you know, to
Di Indonesia perlu kita ketahui bahwa Indonesia sudah mengikuti era 4.0, malah sudah 5.0 seperti itu. Namun masalah digitalisasi bank Islam itu masih ketinggalan dengan bank konvensional, sehingga bagaimana cara-cara atau proses-proses agar bank syariah tersebut tidak ketinggalan dengan bank konvensional terkait digitalnya seperti itu, karena perlu kita ketahui kita sudah mengarah pada 4.0. Mungkin itu saja, Prof. Terima kasih atas waktunya. Assalamualaikum warahmatullahi wabarakatuh.
Prof. Tawad Naipon, do you understand clearly the question?
It's like I missed some of the question. I missed some part of the question. Could you translate that?
Okay.
Send it into English.
She is asking you about digital bank, on your opinion on Islamic finance institution for Thailand. Okay. I think it's about that.
Actually, if in Thailand, Islamic banks is very, and I think they might go for the investment on digital, banking, and it will come with the big issues that a lot of people will lose their jobs as well, like other banks in the country. Thank you very much.
Okay. Thank you very much to Mr. Dr. Tawad Naipon. To the limited time, we do apologize that we can make a new session for question and answer. However, we understand the question is also our concern. That at the end of the question and answer session, I do hope all questions have been answered by our speaker. Sorry.
Cek satu. Cek. Masih cek. Cek, satu. Cek, satu. Cek. Cek, satu. Cek. Cek.
mahasiswa semua. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Honorable Rector of State Islamic University Sunan Kalijaga Yogyakarta, Profesor Dr. Pil Almakin MA, Honorable Vice Deans and Vice Dean of all Faculty in State Islamic University Sunan Kalijaga Yogyakarta. Honorable all invite speaker on student presentation, pembahagian harta pusaka dalam kalangan masyarakat muslim di Negeri 9, satu kajian literatur. Megi Saputra, UIN Sunan Kalijaga Yogyakarta, urgensi pencatatan pernikahan dalam tinjauan Muqasid Syariah Jazar Rauda. Oke, udah 3. Oke, kita mulai ya. Oke.
Cek satu. Cek.
Nanti kamu
Cek. Kan keluar. Cek.
Enggak, aku pakai kamera kan. Kameranya loh.
Cek. Playback juga dong. Coba tes dulu. Cek satu.
udah. Tes 1 2 3. Tes. Oke. Assalamualaikum warahmatullahi wabarakatuh. Honorable Rector of State Islamic University Sunan Kalijaga Yogyakarta, Prof. Dr. Pil Almakin MA. Honorable Vice Deans and Vice Dean of Faculty in State Islamic University Sunan Kalijaga Yogyakarta. Honorable uninvited student presentation, Wan Nur Aina Mardiah, Wan Rusdan, Muhammad Zamro Muda, and Zuliza Muhammad Kusrin, University Kebangsaan Malaysia. Pembahagian harta pusaka dalam kalangan masyarakat muslim di Negeri Sembilan, satu kajian literatur. Megi Saputra, UIN Sunan Kalijaga, urgensi pencatatan pernikahan dalam tinjauan makasid syariah Jazar Rauda. Muhammad Fauzan Niami, UIN Sunan Kalijaga, analisis konstruksi hukum Islam terhadap keputusan Muktamar NU 2010 tentang kawin gantung. And Herdifa Pratama, UIN Sunan Kalijaga Yogyakarta, Mudarobah Mutlaqoh dan Muqayyadah dalam Hukum Positif Indonesia serta analisisnya terhadap aplikasi dan problematika di perbankan syariah. Honorable all present from some university in Indonesia, Honorable all chief and secretaries of department and all selanjutnya oleh Saudara Bayu. Kepada Saudara Bayu disilahkan.
Cek. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh. Selamat sore, salam sejahtera untuk kita semua. Kita baginda Nabi Muhammad SAW, sehingga kita dapat berkumpul sama-sama dalam acara The 5th Annual International Conference. Hardifa Pratama dari UIN Sunan Kalijaga dengan tema Mudarabah Mutalak dan Makayat dalam Hukum Positif Indonesia serta analisisnya terhadap aplikasi dan problematika di perbankan syariah. Mungkin itu tema. Wan Nur Aim Mardiah, Wan Rusdan, Muhammad Zamro Muda dan Zulika Muhammad Kusrin untuk mempresentasikan paper yang telah dibuat. Kepada para pemateri dipersilakan.
Abdul Rahman Shah berpendapat bahawa menyatakan dalam kajian beliau iaitu sama ada tanah yang tertulis, tanah adat ataupun tidak, maka dia tertakluk kepada pemakaian peraturan adat. Manakala Hajah Makiyah Tusarifah pula dalam kajian beliau berpendapat bahawa pemakaian peraturan adat bagi tanah yang tidak tertulis tanah adat hanya boleh dilakukan secara formal di pejabat daripada semua waris. Seterusnya, ada juga keadaan atau isu apabila pendaftaran hak milik tanah adat yang dibuat di pejabat tanah, di mana individu yang dinamakan menganggap tanah tersebut adalah miliknya secara individu. Tetapi peranan atau konsep dalam amalan adat di negeri Sembilan ini, penama hanyalah sebagai pemegang amanah sahaja atas tanah tersebut dan tidak diberikan secara mutlak kepada mereka. Dan perkara ini sebenarnya menyebabkan masyarakat sudah mempersoalkan peranan pentadbir dalam menyelesaikan isu masyarakat yang mengamalkan hukum adat pepatih. Seterusnya yang terakhir iaitu kelemahan pengurusan dan pentadbiran harta pusaka. Iaitu pertama, Zahari Mahat Musa 2018 dalam kajian beliau menjelaskan kelewatan tuntutan ini adalah berpunca daripada sikap waris sendiri yang tidak mengambil berat, dan kebanyakan waris sebenarnya tidak memahami prosedur yang betul dalam tuntutan harta pusaka. Dan perkara ini sebenarnya boleh menyusahkan pihak pentadbir apabila berlaku kes kematian berlapis atau juga situasi kes faraid berangkat. Dan selain daripada itu, kelemahan pengurusan dan pentadbiran harta pusaka ini juga menurut Nuraini Nordin ialah isu yang melibatkan pihak pentadbir, iaitu apabila melibatkan SOP ataupun garis panduan yang diberikan tidak jelas, dan ini memakan masa yang panjang dan juga kos yang tinggi kepada waris-waris yang membuat tuntutan. Dan kesimpulannya, hasil analisis kajian literatur ini mendapati bahawa pertama, ketidakjelasan masyarakat terhadap konsep dan amalan pentadbiran dan pembahagian pusaka di unit pusaka kecil Negeri Sembilan menimbulkan kekangan kepada pihak pentadbir. Hal ini disebabkan kekangan daripada masalah sosial atau sikap masyarakat itu sendiri dan juga masalah perundangan atau juga prosedur yang tidak difahami oleh waris-waris. Yang kedua iaitu kefahaman yang kurang terhadap status amalan adat dalam pembahagian harta pusaka menurut syarak. Dengan mengambil kira status harta tanah adat yang berbeza dengan pusaka bukan adat atau terutama dari segi pemilikannya, maka amalan ini tidak bertentangan dengan syarak kerana tidak melanggar syarat pemakaian hukum adat atau uruf yang dibenarkan di dalam Islam. Yang ketiga, wujud cabaran dan halangan unit pusaka dalam menguruskan pembahagian harta pusaka. Cabaran yang dihadapi oleh pihak pentadbir pusaka di Negeri Sembilan ini dilihat agak berbeza dan rumit berbanding dengan negeri lain kerana adanya tanah adat di negeri. Berdasarkan kepada kajian-kajian terdahulu yang telah dibincangkan, didapati bahawa banyak kajian di Negeri Sembilan cenderung memfokuskan perbincangan kepada amalan pewarisan membabitkan tanah pusaka adat sahaja. Jadi kajian ini mencadangkan agar perlu dibuat kajian lanjutan terhadap prosedur terkini amalan pengurusan harta pusaka di Negeri Sembilan, berangkumi harta pusaka adat ataupun bukan adat, di samping mengkaji halangan-halangan kini yang lazimnya dihadapi oleh pihak pentadbir. Sekian saja perbincangan saya pada hari ini. Maaf atas segala kekurangan. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. Itulah student para presentation dari
Oke. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Di dalam konsep negara atau modern. Yang pertama terkait latar belakang normatif bahwa perkembangan hukum Islam di seluruh Indonesia dan di seluruh dunia, khususnya di negara-negara yang mayoritas Muslim, tentunya telah melakukan pembaharuan khususnya di bidang hukum keluarga yang salah satu materi yang diperbarui adalah tentang pencatatan pernikahan. Kepentingannya adalah bagaimana di dalam sistem bernegara bahwa ketika suatu negara telah melakukan pembaharuan di dalam perkembangan hukum Islam ini, maka akan melahirkan satu perlindungan hukum bagi warga negara tersebut. Karena dalil-dalil yang berkaitan dengan pencatatan pernikahan atau ketentuan hukum tentang pencatatan pernikahan secara normatif tidak bertentangan dengan dalil-dalil secara umum yang ada, gitu ya. Misalnya kita bisa melihat dalil-dalil secara umum tentang bagaimana Rasulullah SAW menganjurkan seseorang ketika melakukan pernikahan itu diumumkan, begitu ya, atau melaksanakan walimahnya agar supaya diketahui oleh khalayak umum, sehingga jelas saat itu dalam kondisi Nabi saat itu adalah bagaimana pernikahan itu tidak disembunyikan atau dinampakkan kepada khalayak umum agar di saat itu terjamin hak-hak bagi yang menikah tersebut. Dalil lain misalnya di dalam Quran surah Al-Baqarah ayat 282 tentang bagaimana tentang bagaimana pentingnya mencatat sebuah transaksi pernikahan. Bahwa dalam tafsir Al-Wasit, Wahbah Az-Zuhani mencatat beberapa transaksi, terutama pentingnya mencatat transaksi ketika kita melakukan transaksi. Meskipun fokusnya adalah tentang hutang piutang, tetapi secara umum bahwa ketika satu transaksi ada bukti transaksi, maka orang tidak bisa menuntut atau orang tidak bisa menuntut hak-hak yang kemudian mereka kehendaki, begitu ya. Nah, oleh sebab itu lahirnya undang-undang pernikahan khususnya di Indonesia yang saya jelaskan adalah mempunyai tujuan dan maksud besar bahwa pencatatan pernikahan itu adalah bagaimana akan saya jelaskan setelah ini nanti bahwa tujuan dan maksud besar adanya pencatatan pernikahan adalah untuk bagaimana orang-orang khususnya yang menikah itu terjamin hak-haknya, terjamin hak-hak yang menjadi hak konstitusionalnya ataupun hak-hak di dalam berkeluarga. Tetapi dalam hal implementasi, begitu ya, dalam implementasi hukum secara sosiologisnya latar belakang ini, bahwa Undang-Undang Nomor 1 Tahun 74 Pasal 2 Ayat 1 dan 2 itu menjelaskan bahwa pernikahan itu sah menurut kepercayaan dan keyakinan masing-masing agama dan dicatatkan, gitu ya, menurut peraturan undang-undang yang berlaku. Nah, pasal ini rukun atau sahnya pernikahan itu berbeda. Artinya hukum Islam dan pencatatan itu tidak bisa disatukan. Artinya pencatatan itu hanya sebatas administrasi. Sementara ada tafsir yang koherensif, bahwa tafsir ini menganggap bahwa pasal 1 dan 2 ini tidak bisa dipisahkan. Kalau sah menurut keyakinan masing-masing, kemudian harus dicatatkan. Karena ketika tidak dicatatkan, maka akan banyak terjadi pernikahan liar, pernikahan tidak dicatatkan, poligami secara liar, dan itu berakibat sangat fatal terhadap institusi keluarga, khususnya istri dan anak-anak. Ini saya sebutkan dasar hukum konteks pencatatan pernikahan dalam konteks bernegara yang bisa saya catat di sini ada 3 dasar hukum, Undang-Undang Nomor 1 Tahun 74, Kompilasi Hukum Islam pasal 5 sampai 7 dan Peraturan Menteri Agama Nomor 20 Tahun 2019 terbaru. Tadi sudah saya sebutkan dasar hukum perkembangan hukum Islamnya. Nah, ini komentar pemikir kontemporer tentang pencatatan pernikahan. Pertama Muhammad Saltut bahwa pencatatan itu bertujuan untuk agar perkawinan itu terpelihara hak-hak dan kewajiban para pihak yang melaksanakan pernikahan, yakni hak-hak suami dan istri, anak dan keturunan. Kemudian Said Sabiq juga berpendapat bahwa penetapan tertulis atau pencatatan pernikahan itu melindungi hak keluarga dan kenyamanan hidup bernegara serta segala pengakuan palsu dan pengingkaran terhadap pernikahan tidak akan terjadi karena ada bukti autentiknya. Pernikahan berdasarkan perintah Nabi yang menganjurkan untuk menyebarluaskan berita pernikahan atau perkawinan. Perkawinan di bawah tangan dalam konteks hukum Indonesia menurut beliau bisa mengakibatkan dosa bagi para pelakunya karena melanggar ketentuan yang ditetapkan oleh ulil amri dalam ini DPR dan eksekutif presiden, sedang dalam Al-Quran memerintahkan menaati pemimpin selama tidak bertentangan dengan hukum-hukum Allah. Nah, sekarang kita dari yang saya ingin bagi share kepada teman-teman semuanya tentang urgensi tentang penyatatan pernikahan ini, ada 2 rumusan masalah yang saya kedepankan. Yang pertama, mengapa pernikahan harus dicatat? Yang kedua, bagaimana urgensi pernikahan dalam tinjauan maqasid syariah Jasur Al-Auda. Untuk pertanyaan pertama, mengapa pernikahan harus dicatat? Setidaknya ada 10 jawaban. Yang pertama, agar terpelihara dan mencapai tujuan perkawinan. Karena tujuan perkawinan itu kan untuk mencapai ketenangan, ketentraman, kebahagiaan. Nah, ketika tujuan ketika pernikahan dari awalnya sudah dirahasiakan atau sudah tidak mau ditampakkan atau tidak mau dilegalisasikan, maka itu sulit mencapai tujuan pernikahan tersebut. Karena nanti akan ada ketidaknyamanan di dalam keluarga. Istri tidak bisa menuntut apa-apa. Itu kemudian ketika terjadi hal-hal yang di luar keinginan di dalam keluarga. Kedua, sebagai bukti atas uang prestasi terhadap suatu pernikahan. Ketika ada pengingkaran terhadap suatu pernikahan, maka itu tidak akan terjadi ketika ada berita tertulis secara resmi. Yang ketiga, dalil tentang pernikahan dan nas yang terkait transaksi yang beberapa pihak melakukan sejalan dengan ketentuan pencatatan pernikahan dalam Islam. Sebagaimana yang disebutkan di awal PPT ini. Yang keempat, mengantisipasi dan mencegah pernikahan, baik itu pernikahan liar maupun poligami juga secara liar, dalam arti pernikahan dapat dilakukan dimanapun seseorang tersebut berada dalam kondisi dan tempat dimanapun. Jadi ketika ada bukti pencatatan, maka petugas akan bisa mengetahui orang tersebut sudah menikah atau belum. Karena yang terjadi di tengah-tengah masyarakat, ketika sudah terjadi permasalahan, barulah kemudian orang itu akan meminta perlindungan kepada negara. Sehingga mengantisipasi itulah kemudian pernikahan-pernikahan liar dan banyak sekali yang kasus-kasus yang bisa ditampakkan. Misalnya pernikahan siri yang dilakukan oleh Bambang Pamungkas, seorang pesepak bola nasional yang sampai saat ini penetapan terhadap anaknya itu masih ditolak oleh hakim, meskipun sekarang dibanding ke pengadilan tingkat banding, pengadilan agama tingkat banding di pengadilan tinggi begitu ya. Tetapi bahwa ketika pencatatan tidak dilakukan, maka suami bisa saja tidak mengakui atau menolak hal yang sudah dilakukan, baik itu terhadap hak-hak istri maupun terhadap keberadaan seorang anak. Yang kelima, menghindari praktek nikah siri yang yakni nikah di bawah tangan yang tanpa dicatatkan. Kemudian sebagai dalil yang meneguhkan dan menguatkan bahwa seseorang mempunyai suatu hak. Berikutnya, untuk membantah dan menyatakan suatu ketidakbenaran atau pengingkaran palsu terhadap suatu pernikahan. Karena baik suami maupun istri bisa saja mengakui suatu pernikahan atau menolak suatu pernikahan. Kemudian untuk membuktikan dan menegaskan bahwa sudah terjadi suatu peristiwa di tempat dan waktu tertentu. Yang kesembilan, dengan adanya regulasi pencatatan pernikahan diharapkan cekcok antara suami dan istri dapat menempuh jalur hukum untuk kemudian mendapatkan hak-haknya di dalam berkeluarga. Yang ke-10, bahwa agar setiap hak dan kewajiban suami dan istri dan anak keturunan dapat terpelihara. Nah, ini kita masuk kepada urgensi pencatatan pernikahan dalam tinjauan konstitusi syariah jasar auda. Secara umum saya membagi 3 hal, yakni bagaimana jasar auda mengkonsepkan konstitusi syariah itu sebagai landasan kontemporer dalam menentukan hukum Islam, dalam menentukan hukum atau perkembangan hukum. Di dalam Konstitusi Syariah Jasar Auda, beberapa hal yang dijelaskan di dalam menjelaskan Konstitusi Syariah sebagai ijtihad kontemporer, yakni di antaranya adalah Konstitusi Syariah untuk membedakan antara tujuan dan sarana pernikahan untuk membedakan antara tujuan dan sarana. Ya, jadi ketika kita berbicara, ketika Konstitusi Syariah yang diajukan yang dipahami oleh jasar auda ini kita praktekkan di dalam pencatatan pernikahan atau kita kombinasikan di dalam catatan pernikahan, bahwa kita bisa mengambil satu kesimpulan bahwa tujuan yang mau dicapai dari pencatatan itu adalah sangat penting, begitu ya. Jadi sarana atau cara itu bisa berubah atau bisa kita cari formulasinya asal tujuannya ini tercapai, begitu ya. Yang kedua, pencatatan pernikahan merupakan implementasi dari kontekstualisasi sarana atau alat. Jadi pencatatan dalam masa sekarang ini selain sebagai bukti yang diakui oleh negara, sekaligus sebagai dasar terjadi suatu peristiwa pernikahan. Jadi sarana atau alat itu merupakan implementasi daripada kontekstualisasi dari sarana atau alat yang dimaksudkan oleh jasar auda, yang perlu kita bedakan antara sarana dan tujuan. Yang ketiga, makosid untuk membuka jalan atau sarana tadi, atau memblokir satu jalan, karena jalan yang dibolehkan atau pintu yang dibolehkan untuk menikah itu boleh saja ditutup ketika dipastikan menikah yang dibolehkan itu ada kemudaratan yang disebabkan. Misalnya memang menikah secara agama misalnya bisa dianggap sah oleh sebagian orang, tetapi akibatnya sangat besar, gitu ya. Ini beberapa saya catat di antara kemudaratan menikah tanpa dicatatkan. Yang pertama, ini masih berkaitan dengan membuka atau menutup, gitu ya, sarana atau yang kita kenal dengan jalan yang dibolehkan untuk jalan yang dibolehkan untuk satu hal peristiwa dalam Islam itu bisa ditutup oleh karena ada kemudaratan di sana. Yang pertama, mudaratnya ketika menikah tidak dicatatkan adalah pernikahan secara hukum tidak dianggap, ya, tidak mempunyai kekuatan hukum. Yang kedua, tidak dapat melakukan pembelaan atas hak-haknya di pengadilan. Yang ketiga, istri tidak dapat menerima warisan dan tidak berhak mendapatkan nafkah ketika suami meninggal atau ketika terjadinya perceraian. Yang keempat, suami dan istri tidak dapat menuntut harta bersama atau harta gondong ini saat putusnya pernikahan. Yang kelima, pasangan akan sulit hidup dan berinteraksi di tengah masyarakat, apalagi jika dimintakan akte nikahnya. Ini saya sebutkan satu kasus begitu ya. Seorang ibu ini sudah melaksanakan 6 kali pernikahan. Jadi ketika pernikahan ke-6 ini sudah 6 kali menikah. Alasannya apa? Karena sudah menikah secara Islam, tidak perlu dicatatkan. Sehingga menikah berulang kali itu bisa dia lakukan. Karena apa? Tidak ada bukti pencatatan. Ya, tapi kehidupan di tengah-tengah masyarakat tidak terjamin. Akhirnya harus ngekos di hotel gitulah dan lain-lain. Ini kondisi di masyarakat. Kemudian yang ke-6 ya, anak yang dilahirkan dianggap anak yang tidak sah secara negara gitu ya. Sehingga anak juga tidak bisa menuntut hak-haknya kepada ayahnya. Kemudian yang ke-7, anak hanya mempunyai hubungan keperdataan kepada ibunya atau keluarga ibunya. Yang ke-8, anak tidak berhak atas nafkah dan warisan ayahnya. Yang ke-9, sebagaimana saya sebutkan tadi, bahwa kerap kali pernikahan yang tidak dicatatkan oleh sebagian orang dijadikan untuk mengumbar hawa nafsunya dengan menikahi siapapun yang dia kehendaki di tempat atau dimanapun dia berada. Begitu. Kemudian analisis yang keempat adalah pencatatan pernikahan merupakan interpretasi dan sebagai yang interpretasi dari apa yang disebutkan oleh Sharia, pengembangan dan pembangunan hak asasi manusia. Bahwa HAM dalam hal pencatatan ini adalah bagaimana hak perempuan dan hak anak begitu bisa terjaga, sehingga landasan untuk pembangunan HAM dan pembangunan indeks pembangunan manusia dalam hal ini bisa tercapai ketika pencatatan itu dicatat dalam hal kondisi sekarang ini, kondisi bernegara ini. Karena dalam kondisi kehidupan sekarang abad ke-20, orang itu hanya mengakui ya yang punya bukti begitu, yang punya bukti yang nyata. Kalau kita mau pergi ke suatu negara, maka kita harus mempunyai visa yang menyatakan bahwa kita bisa masuk ke suatu negara dengan izin tersebut atau paspor begitu ya. Kalau kita mau mengakui bahwa kita ini adalah warga negara dari suatu negara, maka kita harus mempunyai bukti berupa kartu tanda penduduk suatu negara itu. Kalau tidak, kita tidak bisa mengakui. Kalau kita mau mengakui satu harta adalah hak milik kita, maka kita harus punya sertifikat bukti bahwa kita pemilik dari harta tersebut. Sehingga dalam pencatatan ini terkandung HAM atau pembangunan manusia dalam hal ini adalah bagaimana generasi yang akan dibangun atau anak-anak keturunan. Nah, ini pemahaman masyarakat tentang pencatatan pernikahan yang berkonsekuensi juga terhadap bagaimana penerapan hukum. Tadi sudah saya jelaskan di awal ada interpretasi terhadap hukumnya, dan secara garis besar di masyarakat itu ada dua pemahaman ini, sehingga kita tidak bisa menolak hal ini terjadi, tetapi dalam pandangan saya dengan kita menganalisis pencatatan pernikahan ini karena sangat penting di dalam hal menjaga hak-hak dan menjaga institusi keluarga, maka kita harus merevitalisasi tentang aturan pernikahan ini agar bisa masyarakat paham. Jadi tidak hanya pembuatnya yang paham bahwa undang-undang itu menyatakan bahwa pernikahan itu sah ketika dilakukan menurut keyakinan dan kepercayaannya masing-masing.
Izin tinggal 1 menit lagi.
Dan harus dicatat, bukan hanya DPR saja yang paham itu, tapi juga masyarakat secara umum mengetahui dan paham bahwa mencatat pernikahan itu adalah suatu hal yang sangat penting untuk menjaga hak-hak mereka.
Kawin gantung. Kepada saudara, waktu 15 menit untuk presentasi dipersilakan dari sekarang.
Cek. Bismillahirrahmanirrahim. Mengikat saja, digantungkan saja. Karena nanti ketika setelah balik, setelah usia dewasa, maka orang tua itu akan menikah. Oleh karena itu, peneliti di sini memberikan telah pustaka untuk membuat posisi dari penelitian yang dikaji oleh peneliti. Yang pertama yaitu telah mengenai penelitian dari Ahmad Husaini yang membahas mengenai pandangan ulama Ponorogo terhadap putusan Muktamar NU ke-32 tentang kawin gantung. Lalu yang kedua ada juga penelitian dari Muhsofil Mubarak yang membahas mengenai perbandingan keputusan NU tentang batas minimal usia menikah dengan peraturan perundang-undangan di Indonesia. Lalu ada juga penelitian dari Khaironi Agza yang membahas tentang sebab terjadinya kawin gantung dan proses pelaksanaan kawin gantung itu sendiri. Lalu yang terakhir yaitu ada penelitian dari Aliza Usman dan juga Ermali Aliza yang fokusnya kepada tradisi nikah gantung tersebut dalam kehidupan masyarakat Pulau Selatan. Tinjauan perspektif hukum Islam. Tetapi artikel di sini yang saya ajukan yaitu fokus kepada konstruksi putusan Muktamar NU yang ke-32 mengenai tentang kawin gantung serta saya analisis dengan menggunakan peraturan perlindungan anak yang akan disajikan. Oleh karena itu model dari penelitian ini yaitu penelitian library research dengan pendekatan normatif karena mengkaji putusan Muktamar NU ke-32 juga menggunakan pendekatan conceptual approach yaitu berupa mengkaji konsep-konsep dari hak perlindungan anak itu sendiri. Yang 14 mengenai perlindungan metode yang langsung mengacu pada pendapatnya para ulama yang ada pada teks kitab Muktabarah tersebut. Lalu kedua yaitu metode ilhaqi, di mana ilhaqi itu sama seperti qiyas, tetapi bedanya di sini yaitu menyamakan hukum yang ada pada kitab dengan hukum yang tidak ada pada kitab karena ada faktor kesamaan ilatnya itu. Lalu yang ketiga yaitu metode manhaji, yaitu metode yang mengarungi jalan pikiran dari imam para mazhab itu sendiri. Konstruksi dari putusan Muktamar NU itu bereksplisit tidak ditemui dalam kitab-kitab Muktabarah. Oleh karena itu tidak ditemui dalam kitab-kitab Muktabarah, para mu'tamirin itu melakukan metode selanjutnya yaitu metode ilhaqi. Yang mana metode ilhaqi itu menyamakan kasus-kasus yang mempunyai kemiripan dalam kitab-kitab Muktabarah. Nah, setelah dikoreksi ternyata mempunyai titik kesamaan antara kawin gantung itu dengan pernikahan di usia dini dan juga hak ijbar dari adalah kawin gantung karena tidak ada teks kitab yang secara eksplisit itu menjelaskan mengenai kawin gantung itu seperti apa. Lalu yang kedua yaitu ada mulhaq alaih, yaitu hukum dalam kitab Muktabarah di pernikahan di usia dini dan juga hak ijbar orang tua terhadap anak. Lalu yang menjadi wajuhul ilhaqnya yaitu yang kedua yaitu development right, yaitu hak untuk berkembang. Yang ketiga yaitu participant right, yaitu hak untuk berpendapat. Lalu yang keempat yaitu protection right, hak untuk memperoleh perlindungan. Lalu ada juga kelangsungan akan kehidupan, berkembang, bertumbuh dan mendapatkan perlindungan dari sikap diskriminasi. Lalu pada UU nomor 35 tahun 2014 itu pada pasal 26 pada poin yang pertama itu menerangkan bahwasanya orang tua itu berkewajiban dan bertanggung jawab untuk mengasuh, memelihara, mendidik dan juga melindungi anak. Yang kedua yaitu menumbuh kembangkan anak sesuai dengan kemampuan, bakat serta minatnya. Lalu yang ketiga yaitu mencegah terjadi perkawinan pada usia 18 tahun. Lalu yang ketiga, yang terakhir yang nomor 4 yaitu memberikan pendidikan karakter dan penanaman nilai budi pekerti pada anak. Oleh karena itu kalau kita sampingkan dengan peraturan perlindungan anak, maka usia menikah dini ini itu bertentangan dengan hak development right seorang anak. Yaitu yang mana anak itu seharusnya itu memperoleh standar hidup yang nyata dari segi psikologis, segi mental, segi spiritual maupun segi moral. Yang mana ketika kita mengkaji pernikahan dini, rasa cemas, kebingungan. Karena apa? Karena tidak menikah pada usia yang tidak pada usia yang standar. Melainkan usia-usia yang sangat muda seperti yang tadi saya jelaskan, yaitu usia umur 10 tahun. Lalu yang kedua yaitu menikah dini itu bertentangan dengan hak survival rights, yaitu perawatan yang layak bagi seorang anak. Yang mana anak itu seharusnya diberi perawatan yang sangat standar, baik dari segi kesehatan maupun aspek yang lain. Karena ketika kita membiarkan anak dengan membiarkan anak begitu saja, maka sama saja kita itu mendiskriminasi anak kita itu sendiri. Lalu yang selanjutnya yaitu bahwa wajahul ilhaq yang menempatkan pada menikah di usia dini itu bertentangan dengan UU nomor 35 tahun 2014 pasal 26 ayat C yang menerangkan yang mana seharusnya orang tua itu mempunyai kewajiban untuk mencegah anaknya menikah di umur kurang dari 18 tahun. Kalau kita menelaah UU yang sekarang, UU perkawinan yang terbaru, itu batas minimal usia pernikahan di Indonesia adalah umur 19 tahun. Tetapi pada prospek empirisnya terjadi perbedaan, yaitu anak-anak sering sekali dinikahi pada umur 10 tahun, 12 tahun, atau yang tidak standar dengan UU perlindungan anak ini. Lalu wajibul ilhaq yang diajukan oleh putusan itu mengenai hak ijbar itu juga tidak relevan dengan konteks saat ini, karena bertentangan dengan muatan tadi itu Convention on the Right of the Child tentang participation right, yaitu hak-hak yang meliputi hak menyatakan pendapat dipressure oleh orang tua, dan itu yang tidak boleh dilakukan oleh orang tua. Lalu yang selanjutnya yaitu bertentangan dengan deklarasi HAM pasal 16 yang mana pernikahan itu hanya dilakukan persetujuan bebas sepenuhnya dari para calon mempelai laki-laki. Begitu juga dengan perkawinan Indonesia nomor 174 yang mana pada pasal 6 itu tertera secara jelas bahwasanya pernikahan secara sah itu apabila berlandaskan
kepada saudara Herdiva mohon dibuka di on cam dulu zoomnya.
Oh ya, cek kedengaran suara saya?
Oke, kedengaran. Oke, waktu 15 menit diberikan dari sekarang.
Oke, baik. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah wa syukurillah. Wassalatu wassalamu ala Rasulillah wa ala alihi wa ashabihi wa mawalah. Wa la hawla wa la quwwata illa billah. Wadina billah rabbah wa bil islami dina, Islam, human right and legal justice. Semoga setidaknya dari majelis kita hari ini mendapat barokah tentunya. Amin amin ya rabbal alamin. Ini screen saya sudah kelihatan. Halo. Arah artikel ini di mana akan tiga goals yang kita harapkan dari pembahasan kita, yaitu yang pertama bagaimana keberadaan mudharabah dalam hukum positif Indonesia, kemudian bagaimana analisis terhadap aplikasinya di perbankan syariah hingga berakhir pada apa sih problematika yang ada di perbankan syariah itu terkait mudharabah ini. Sebelum sampai situ kita akan terlebih dahulu sedikit mengulik mengenai perbankan syariah ya. Kita mengetahui bahwa perbankan itu lembaga yang mempertemukan antara orang yang memiliki surplus dana atau surplus unit dengan orang yang memiliki kekurangan dana, defisit unit.
uniknya di bank syariah itu dipertemukan dengan sistem profit and loss sharing atau sistem saling bagi untung dan rugi. Kemudian bagaimana dengan perkembangan bank syariah saat ini di Indonesia khususnya? Dari data-data yang sudah kita dapatkan, berbagai telaah website resmi dan dari outline, kemudian outlook dan landscape beberapa lembaga keuangan, didapati bahwa ternyata pertumbuhan aset perbankan syariah di Indonesia itu mencapai angka 12,8% di tahun 2021, per Maret 2021. Kalau kita bandingkan dengan perbankan konvensional, itu jauh lebih tinggi. Artinya ada simbol baik dari perkembangan bank syariah saat ini. Dan bahkan jika dibandingkan dengan industri perbankan nasional secara keseluruhan, itu juga lebih tinggi pertumbuhan aset perbankan syariah. Kemudian kita lihat indikator yang lain, market share. Pangsa pasarnya bagaimana dari bank syariah ini. Ternyata di Desember 2020 itu, pangsa pasar bank syariah itu mencapai angka 6,51%. Bahkan kalau dibandingkan dengan tahun sebelumnya, di tahun 2019, itu hanya sekitar 5,9%. Artinya apa? Peningkatan ini menunjukkan adanya increase yang positif, siklus yang baik dari pertumbuhan dan perkembangan Bank Indonesia, Bank Syariah di Indonesia. Tidak cukup dari dua indikator ini saja. Mungkin bisa kita analogikan bahwa mayoritas umat Islam yang ada di Indonesia, yang Wikipedia mengatakan 86,2% perkembangan bank syariah di Indonesia saat ini. Terlebih lagi nanti belum lagi keberadaan bank atau mungkin LKS yang lain yang muncul yang sangat banyak saat ini, menjamur sekali. Sehingga banyaknya perkembangan yang positif tadi, indikator yang menunjukkan tren positif dari perbankan syariah tadi, perlu kita tinjau rasanya apa saja produk-produk yang aktivitas-aktivitas yang dilakukan bank syariah sehingga mencapai tren positif seperti tadi. Kalau kita lihat salah satu di antaranya yaitu mudharabah. Mudharabah ini kita lihat sepositif perkembangan secara umumnya. Memang pembiayaan di bank syariah itu secara teoritis itu terbagi dua, ada yang musyarakah dan ada yang mudharabah. Namun kalau kita analogi secara lebih dalam, secara psikologis, melalui mudharabah ini kita mendapat bantuan dana yang sangat besar. Ya, nanti kita akan coba sampai mengenai teoritis dari mudharabah ini. Namun sayangnya mudharabah itu pula potensinya belum sampai dimanfaatkan oleh bank syariah. Kalau kita lihat datanya hanya menempati peringkat keempat dari 5 akad pembiayaan di bank syariah. Bahkan cenderung itu pembiayaannya menurun dari tahun ke tahun. Bahkan sampai di tahun 2020 itu anjlok sekitar 14%. Dari 13 miliar sampai kepada 11 miliar. Ini kan suatu hal yang perlu kita telaah. Apa sih sebenarnya permasalahan yang menyebabkan mudharabah ini tidak berkembang baik layaknya perkembangan positif dari bank syariah tadi. Maka dari itu artikel kualitatif ini mencoba untuk menyajikan hal-hal tersebut, problematika, aplikasinya bagaimana hingga keberadaannya di hukum positif Indonesia. Kita ulik sedikit mengenai mudharabah dalam konsep teoritis ya, sebelum kita sampai kepada hasil artikel nantinya. Allah berfirman, wa akharu yadribuna fil ardh yabtagu min fadlillah. Al-Muzammil ayat ke-20. Memang kalau kita lihat secara tekstual, dalil tersebut tidak mengatur secara eksplisit mengenai mudharabah. Hanya disebutkan ya bertagu min fadlillah, carilah olehmu karunia-karunia Allah Subhanahu wa taala. Kedua hal tersebut artikel kualitatif dengan metode deskriptif analitik. Saya coba menggambarkan dan menganalisis fenomena-fenomena mudharabah dalam hukum positif Indonesia dan problematikanya nanti dengan analisisnya nanti konten analisis ya dari studi kepustakaan yang sudah ditelaah sebelumnya. Mudharabah dalam hukum positif. Saya mengelompokkan keberadaan mudharabah ini ke dalam dua bentuk hukum positif di Indonesia. Ya. Yang pertama yaitu dalam konstitusi atau undang-undang. Ini bentuknya implisit ya. Artinya kalau kita berbicara implisit mengenai UUD 1945 dasar negara kita pasal 29 ayat 2, 1 dan 2 tentang kebebasan memeluk agama dan menjalankan syariat agama ya. Di sini lahir bahwa ekonomi syariah sebagai bentuk umat Islam menjalankan syariat-syariat dengan dalam lingkup yang besar. Mudharabah dalam lingkup yang kecil, artinya mudharabah sebagai produk ya. Ada beberapa produk yang
dikaitkan dengan mutlaqah dan muqayyadahnya mudharabah di perbankan syariah. Kalau kita tinjau pertama, mudharabah mutlaqah dalam perbankan syariah itu terjadi pada aktivitas penghimpunan dan pembiayaan, ya, tanpa ada batasan dari sayyidul mal. Mudharabah muqayyadah uniknya pada aplikasinya di perbankan syariah itu dibagi menjadi dua jenis. Ada mudharabah muqayyadah on balance sheet dan mudharabah muqayyadah off balance sheet. Ya. Di mana mengapa dibedakan dua hal ini? Ternyata alasannya adalah jadi pada mudharabah penghimpunan itu adalah nasabah dan mudharib itu adalah bank. Namun pada muqayyadah itu nasabah sebagai sayyidul mal dan pengusaha nantinya itu sebagai mudharib dan bank sebagai perantara yang mempertemukan kedua pihak tersebut. Jadi bank sini tugasnya sebagai intermediari atau perantara kedua pihak tersebut. Inilah detil-detil produk yang diaplikasikan di perbankan syariah melalui mudharabah. Ada produk penghimpunan, melalui mutlaqah, tabungan berjangka seperti usaha dan sebagainya. Kalau mudharabah muqayyadah on balance sheet hanya melibatkan dua pihak, itu deposito spesial, deposito yang nasabah itu request ini akan dialokasikan ke usaha yang mana. Sedangkan mudharabah off balance sheet itu bank mempertemukan antara nasabah dengan pengusaha dalam bentuk investasi khusus, di mana nanti bank ini akan mendapatkan komisi atas pertemuan itu, sedangkan nasabah dan pengusaha tadi akan melakukan mediasi. Inilah problematika yang muncul dari akhir artikel kita mengenai pelaksanaan mudharabah. Alhasil, kesimpulan yang dapat kita ambil dari artikel ini adalah ternyata hukum positif Indonesia telah menjadi salah satu norma yang melegalkan melegalkan pelaksanaan mudharabah, baik itu dalam bentuk sistem perbankan syariah, dalam bentuk ternyata mudharabah itu menyimpan potensi dalam meningkatkan perekonomian umat, maka dari maksimal pada aktivitas-aktivitas dan produk-produk yang dipaparkan tadi. Dan yang terakhir, guna menunjang keberhasilan pelaksanaan mudharabah di Indonesia dan di perbankan syariah dari nasabah dan mudharib dan
Thanks for time. Terima kasih. Pertanyaannya tertuju kepada Mas Peggy sebetulnya ya. Dalam teori makosid ya, yang berakhir pada purposefulness tadi, kebermaksudan dari teks gitu ya. Nah, dari pendekatan sistem jasa auda, maka urgensi pencatatan. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Langsung saja persilakan kepada Mas Megi untuk menjawab pertanyaan makasid yang kemudian itu dijelaskan oleh Jasir Auda. Ada umum, parsial, dan khusus. Nah, sementara di dalam presentasi tadi ada beberapa pernikahan, kemudian itu masuk dalam level yang mana. Mungkin itu kami persilakan kepada Mas Megi.
Baik, terima kasih kepada penanya. Kita mengetahui bahwa memang Jasir Auda ini di dalam mengembangkan makosid itu membagi jangkauan supaya makosid itu lebih menjaga begitu ya, menjaga agama dan yang kita kenal 6 hal yang menjadi kebutuhan dasar daripada hidup manusia. Tapi ketika makosid syariah dikembangkan oleh Jasir Auda, ini yang kemudian menjadi konsep pembaharuan makosid. Jadi makosid syariah dibagi menjadi 3 jangkauan. Pertama makosid umum. Nah, makosid umum ini menjangkau makosid yang dijelaskan ada 6 tadi, ditambah dengan prinsip-prinsip dasar tentang keadilan, gitu ya, tentang kebersamaan dan lain-lain. Kemudian ada juga jangkauan makosid secara khusus yang di sini kita bisa melihat memang secara khusus terkait dengan kepeterdataan dalam ini, misalnya tentang institusi keluarga, perlindungan institusi keluarga, kemudian perlindungan hak-hak bagi anggota keluarga, dan lain-lain. Kemudian juga makosid yang secara parsial, ya ini bagaimana makosid itu jangkauannya menelaah bagaimana maksud dalil dari hukum yang tidak hanya dipahami sekedar perintah atau larangan, tetapi juga hikmah di balik dalil yang disajikan. Oleh sebab itu, dalam spesifikasi ini, kalau kita bertanya tingkatannya, maka kita bisa melihat bahwa pencatatan pernikahan ini kita masukkan ke dalam tingkatan yang kedua, yaitu spesifikasi dalam hal ini jangkauannya adalah untuk melindungi institusi keluarga. Meskipun di jangkauan yang umum juga bisa dimasukkan, karena ada penjagaan di dalam hal ini adalah penjagaan terhadap keturunan, karena keturunan itu juga termasuk maksud daripada lahirnya pencatatan pernikahan, karena agar anak itu terjamin hak-haknya. Begitupun harta, misalnya terkait harta waris dan lain sebagainya. Oleh sebab itu, dalam pengajian ini saya tidak fokus dalam memang jangkauan ini, tapi saya menganalisis bagaimana Jasar Auda kemudian mengatakan makosid syariah itu menjadi landasan kontemporer di dalam penetapan hukum.
Baik, kalau tidak ada. Oke, yang mau bertanya silakan on mic.
Oke, untuk mengingat